Item for delivery of judgment. Item number 39. CRT 7 of 2026.
Petition
Call first. Records can record only the contract. This is up to date closure. Alia put up the destination. Yes, but I have mentioned.
ট্ৰায়েল কোৰ্টৰ ৰেকৰ্ডটো আগতে আমি কল কৰিছিলো চাগে ট্ৰায়েল কোৰ্টৰ ৰেকৰ্ডটো আগতে আমি কল কৰিছিলো চাগে এইটো টেক কৰি দিলে হ'ল নহ'লে আকৌ
Next day, कितना?
আগৰ অৰ্ডাৰ আছে ৰিজেকশ্যন হোৱা
It also at my land. Yes, my lord. 2 days fixed. They also fixed for evidence for it. My land flats are
today
my lord.
okay earlier also we have called for the record
Yes, my lord.
will the director raise it to take that bail application with this application with record and this witnesses so far examine you produce the certified copy
My lord.
Heard Mr. R. Islam, learned counsel for the petitioner, and Mr. Goswami for the learned additional paper for the state respondent. This application under section 483 of the BNSS 2023 is preferred by the applicant. The preferred by the accused, who has been languishing in jail as since 12/11/2024 in connection with session case number 366 of 2024. Arising out of Agamon appears case number 98 of 2023 under section 120B 30234 IPC. Mr. Islam, learned counsel for the petitioner, submits that this is second or third bail. Third. That this is the third bail application preferred by the accused and the earlier applications. No, and the second application was rejected by this court by order dated 9/12/2025 in BA number 3503 of 2025. Mr. Islam further submits that though 21 witnesses have been cited in the search sheet till date, only 6 witnesses have been examined. And there is no immediate chance of completion of trial, and under such circumstances, he is contended to allow this petition. On the other hand, Mr. Goswami, learned additional paper, submits that trial court record will be required for disposing of the present petition. However, it is submitted that earlier the record of the trial court was called for in bail application number 3503 of 2025. And accordingly, it is provided that registrar shall take the record of bail application number 3503 of 2025 with this petition and list the matter on 9th of March. And in the meantime, Mr. Islam, learned counsel for the petitioner, shall obtain certified copy of the witnesses, copy of the deposition of the witnesses, and shall produce the same before this court on next date.
Obliged.
For motion item 2.
May it please your lordship. Lordship may kindly pass the matter for time being. My senior is on lax in court number 22.
Item 3.
May I please your lordship. My lord, the dispute between regarding the name of one school, my lord. That is Hukuapata BRME High School and Hukuatepa High School, Rauli. Now kindly see the impugned order, that is on 14/11/25, page 16.
Yes.
With reference to the subject cited above, I would like to inform you that as per Director of Secondary Education, Assam, letter number so-and-so, that is so-and-so, the undersigned to constitute an inquiry committee, page 16, where this office letter number so-and-so, that is so-and-so, of B.R. Milan High School. The inquiry committee stated that the school signboard initially displayed the name as B.R. Milan High School, Post Office, Ravli, District Borpeta, established in the year 1976, which also appeared on the school certificate, board registration certificate, etc. Under the above circumstances, the inquiry committee recommended that in the interest of the public, school name be renamed, remained unchanged, that is B.R. Milan High School, Post Office, Ravli. So here, two questions are here. The inquiry committee was constituted. An inquiry committee submitted their report. But both the inquiry committee and this report were not furnished to us. Now, this order was passed on 14/11/25. Now, kindly come to page 17. B.R. Milan High School, Bhukuatepa. Here, Bhukuatepa, it is 17/4/25.
No,
Just after
Mr. Mahmood, where is the impugn order?
impugn order, page 16.
16.
16. This impugn order was passed on 14/11/25.
How you are aggrieved?
Hello?
How you are aggrieved by this order?
Yes, because the school is situated in our village. Bhukuapeta village, the school is situated to that. I am coming later on.
No, Mr. Mahmood, this is one of the letter issued by the inspector of school to the headmaster. Which order is being challenged in this revision petition?
Actually, my lord, there was a title suit also filed before the learned.
Which order?
civil
Which is the impugn order?
impugn order 16.
16 is a letter.
Inst-
And this letter you cannot challenge in this civil revision petition. You have to file a writ petition under Article 226.
That, my lord, the matter was inquired before the registry. Registry CRP IO would be there. Because there was a civil case, that is also under challenge. But for the time being, we are not giving any emphasis on the civil court's order. We are only name of the school. Kindly say.
No, that cannot be dealt with in this civil revision petition. Had it been an order passed by the trial court, then it
Trial
could
court
have been
returned
challenged.
the suit.
This is only a letter.
My lord, trial court returned the suit on the ground that the notice under section 80 was not properly served and though petition was there, that was not considered. Now CRP, my lord, let me satisfy your lordship.
No, you see this 14/11/2025 is a letter.
This is the impugned order. But what was the necessity of passing this order? Let me satisfy your lordship.
No, we cannot deal with the same in this revision petition.
My lord, when we filed the CRP IO, registry did not raise any objection.
No, registry did not raise any objection. That does not mean that this court will
I
admit.
understand that. And we are also confused.
You obtain instruction, otherwise we will dismiss it with cost. After some time.
Item 4,
Administrative order you are challenging in civil revision petition.
Yes. But
Where it is provided, under which
Honorable High
purpose you
Court,
are challenging it.
in earlier occasion, High Court passed order, this matter was not raised.
You go to that court then. List the matter before another bench without me.
No, we are not on that. Let me take
No,
instruction.
you go wherever you would like.
item 4,
Then after some time.
No. I will not take up the matter.
May Mr. Mati,
Yes.
here we have to file an additional affidavit to incorporate the miscase number 232/24, but the person concerned could not come, my lord. The matter may come, my lord, next week, my lord. In the meantime, they have also filed affidavit in opposition in that case. At a time, reply also will file.
Okay. Mr.
Next week, any day in the
Mr.
next week.
Fina, learned counsel for the petitioner, and Ms. Esper, learned counsel for the respondent. Mr. Sinha, press for listing the matter in the next week so as to enable him to file an additional affidavit.
Yes, my lord.
Bringing on the record the
Yeah, miscase number 232/24.
case number 232/2024. Parallel, this is a list the matter in the next week.
All right.
item 5,
May please, my lord, I have filed this case for regarding, citizens, the order dated, my lord, 17/1/2023. That is passed by the, I have filed this case, my lord, citizens, the order dated, my lord, 17/1/2026, passed by the learned principal judge number 2 Kamru Metro, regarding FC civil case number 494/27, 2017, my lord. That the opposite party shall meet the minor trial on second and fourth Sunday every month from 10 to 12 p.m. That is the, my lord, and subsequently the case is filed only for the judicial separation. In that, another case already pending, my lord, that is guardianship case. So, order is passed in guardianship case, but not in guardianship, it is passed in judicial separation case, my lord. As such, the Honorable Principal Judge number 1 verbally stated that they are not meet his side, because it is the case is only for judicial separation, not a guardianship. One guardianship case is pending, my lord, and accordingly thereafter, my lord, and in this matter they are admitted, my lord, in here title sheet page 20/20 to 39, my lord, in paragraph 5, my lord, page 20. They are filed another civil suit for 23. Plaintiff herein said that during the proceeding, the pending of the aforesaid case, judicial separation, the Honorable Principal Judge, Family Court number 1 has cancelled the visiting right of the plaintiff without passing any specific order, and verbally instructed the defendant number 1 not to allow the plaintiff to meet his daughter. A copy of order dated I have annexed, my lord, and as such and the minor child is hesitant to meet
The order dated 18/8/2017 and 18/9/2018 and 17/1/2026 passed by the learned principal judge Number 2, Kamrup Ma'am, in connection with FC civil case number 494 of 2017. Peruse the petition and the documents placed on record. And also peruse the impugned orders dated so and so. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by post and also by usual process within a week from today. List the matter after 2 weeks. Interim
Kindly
period
date
of
may
the
be fixed,
petition.
my lord.
Okay. Interim period of the petitioner will be considered on next returnable date.
8 March.
18 March. My
Item
lord.
number 8.
Wait, Your Lordship.
Mm.
In this matter, I am challenging the order whereby the authority has, whereby the court below has directed for payment for police help. Whatever, what happens? The plaintiff made a suit claiming that I have disposed from a property, and therefore for recovery of possession of a particular three kotha bill. In that case, I filed my counterclaim also. After hearing that it was declared that I have right title interest over my purchased land.
You have?
I have right title and interest over my purchased land. Accordingly, I put a boundary wall on the land. On 7th February, the civil Nazir went to the spot and he told me to break a part of my constructed wall so that decree can be executed. But I have the right title interest over my parcels and therefore that is illegal. They told that that should not be broken. So therefore the Nazir submitted a report. That report is at page 43 and vernacular is at page 45 is the vernacular portion also. আজি ইংৰাজী 7/2/2026 তাৰিখে ডিগ্ৰীদাৰ হৈ বিবাদীয় জমিত উপস্থিত হওঁ। এই জমি দখল দিবলৈ হলে লাটৰ লাটমণ্ডল বন্দুকধাৰী আৰক্ষী ও মহিলা আৰক্ষীৰ প্ৰয়োজন হ'ব। সেয়েহে দখলী পূৰণৰ কাম সম্পূৰ্ণ কৰিব নোৱাৰি বিৰোধী মহাদেৱ জনালে। Now thing is that Lordship, that police help part Lordship because the land should be first identified. And my apprehension is that since he is asking me to broke a part of the land, the decree will be executed by breaking my own land. Breaking wall of my and making a road on my own land. Therefore, I am coming for stay of that order. Now, thing is that Lordship, it is a clear rule that before passing an order for police help, court should come to a satisfaction that yes, police help is necessary. I may be issued notice to represent my case. That was not done. The order is at page 46. I'm reading
No. Whether you have been notified that on that day the civil Nazir and Latmandal will proceed to the suit property for delivery of the possession.
Latmandal did not go, only the civil Nazir went. No notice was issued to me prior to that. After the civil Nazir went to the spot, then only I entered and found that the execution case is pending. Then only I got the information. I did the order, page 46. Decree holder is represented, civil Nazir has submitted a report regarding to warrant of possession issued has returned. I have produced the same report. In the report, it was mentioned that for execution of the decree with the help of armed forces, including women police and revenue authorities required. I have heard the learned counsel for the decree holder, where is the case record. Therefore, upon consideration of the report and the submission of the learned counsel, I deem it fit to direct the decree holder to deposit the police post in the government treasury and submit the receipt before the court on the next day as per law. Now, I want to rely Rule 203 of Civil Codes Rules and Orders of Gauhati High Court.
Correct.
I am forwarding my book also. This rule 203 towards the end, it is written that the police help is an extreme step, Lordship. It should not be ordered normally.
Yes, 203.
203. I
Yes.
check mark that. Also. Yes, your Lordship will find paragraph number 6. When the police help may be given. This court observed in the case of Ratonbai versus Chatwarao.
No, here, Mr. Sharma, you say, there is a report of civil Nazir.
Yes, Lordship.
So on the basis of report of the civil Nazir, the learned executing court has arrived at a finding that police help will be required.
Yes, Lordship.
So what wrong with this?
Lordship, first of all, the property should be identified. The boundary given. to
Whether
the
you have filed any application before the
Lordship,
executing
I
court?
submitted.
When?
On 16th Feb.
16 February.
Yes, Lordship. Case of 6 on that, I filed one application stating all that.
But in this order, there is no reference to that application filed by you.
No, it was that order is on 10th of February.
Hmm.
And I filed
And when
application
you
on
filed the
16th
application?
16th of February.
16th of
Yes.
February.
Case is fixed for objection on 2nd of March. Lordship,
Okay, then let the
paragraph 6 of the judgment, Lordship, I have just provided. It is no doubt that the police help is an extraordinary mode or procedures to implement the execution of the decree or orders. In other words, police help is to be regarded as an extreme step, and as such, it should not be recommended unless the court is fully convinced of the existence of grave emergency. Therefore, a decree holder praying for police help has to state whether such help is required, either because apprehension of violence or obstruction from the offender himself or at his instance by others, or because of condition of a general character such as locality where execution will be have to be effected, being in a disturbed state, or a class of people similarly situated being likely to make a common cause with judgment debtor and resist execution. Thus, the special procedure for police help could not be allowed unless there are reasonable grounds to suppose that the execution will not be effected without serious danger of public peace because of intention of violence or obstruction from the judgment debtor himself, or because of condition of general character as such where the execution will have to be done in disturbed state, or class of people similarly situated being likely to make common cause.
Mr. Sharma, you see, this is the decision of Bombay High
Bombay
Court.
High Court.
There may be rules and regulation there, but in our rule, that can be.
Yes. Also, 203 also state that
The requirement is that the executing court has to derive its satisfaction.
yes, Lordship. Now,
Here
your
also
Lordship,
there is a report of the process server.
yes, it is a
No, civil Nazir.
yes, it is. It does not reflect anything that there is some danger or something like that.
Hmm?
And the court also did not record its satisfaction
Hmm.
that police help is necessary. Also, my prayer is that the Latmandal should go, he should identify the land, then if it could not exist, then court may issue police help. But prior to that,
First, let us
apprehension
say
is that-
what order is to be passed by the learned executing court on the petition filed by you. That has been fixed on
fixed on 3rd of March.
3rd of
2nd
March. We'll take it up on 6th of March. This matter.
On that day, case is fixed for filing objection by the decree holder side. So
Yes.
there may not be any effective order on that day.
Okay, then after 2 weeks. After 2 weeks. Mr. R. Sharma, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 10/2/2026 passed by the learned civil judge Junior Division Baska. In title execution case number 10 of 2025. It is to be noted here that by the impugned order dated 10/2/2026, the learned executing court has directed the decree holder to deposit police costs in the Gov Treasury and to submit a receipt before the court before next date. Mr. Sharma, learned counsel for the petitioner, referring to Rule 203 of the Civil Court Rule and Practice of Gauhati High Court, submits that before sending requisition for police party, the executing court has to arrive at a satisfaction that police help will be required for getting the decree executed. But in the impugned order dated 10/2/2026, the learned executing court has not recorded its satisfaction. And further, Mr. Sharma submits that before the decree is executed, the Latmandal has to identify the decretal land. And to that effect, the petitioner has filed an application before the learned executing court, and the same has been fixed on 3rd of March.
2nd of March.
2nd of March 2026 for filing objection. In view of the submission of Mr. Sharma, learned counsel for the petitioner, it is provided that justice shall raise the matter after 2 weeks. And apprise this court about the outcome of the petition filed by him before the learned outcome of the petition filed by the petitioner before the learned executing court. List accordingly. Okay.
I shall do it by filing affidavit lodge.
Mr. Sharma shall bring on record the order.
I have an another petition also in this case, so I shall bring that also. The affidavit.
Bring on record the petition and also the order passed by the learned executing court upon the petition filed by him by way of an affidavit.
Obliged.
Bye.
May it please your lordship. 227, Article 227 petition, my lord, because Section 16, there is a appellate authority which has not been formed under, by the state government. So this petition. So,
Under Land Grabbing Act.
no, my lord, this has been a Special Act Maintenance and Welfare of Parents and Senior Citizens Act 2007.
Okay.
My lord, this is a second round of litigations. My lord, may I take your lordship to page 16? Now, under this particular 2007 Act, a petition was filed by the respondent number 1 at page 16, my lord, will kindly come to. And that petition was dismissed by the order dated 28th July 2024, wherein the tribunal came to a finding with regard to that he have enough resources. So far with regard to his property is concerned, it's a civil dispute. Now, this order was challenged in a writ petition, my lord. That writ petition, my lord, at page 17. And the judgment and order, we are heard, both the parties were heard, and the judgment was pronounced at page 42, my lord, will kindly come to. And this judgment is based on a Supreme Court judgment reported in 2015, my lord. And wherein it said that even the senior citizen, the parents have a right to evict the son or the family members.
Hmm.
That is the judgment on the basis of which the operative portion of the judgment is at page 61 of the judgment, my lord. We'll kindly come to that. Accordingly, the present representative stands allowed to the following extent. The impugn order dated 27/24 stands set aside and quashed, being passed without jurisdiction inasmuch as the maintenance officer acted like a tribunal without having such power and jurisdiction. The petitioner is permitted to approach the jurisdictional maintenance tribunal by filing an application under section 5 of the Act 2007. The tribunal shall thereafter proceed with the application of the petition in terms of the Act of 2007 and within the period prescribed under subsection 4 of section 5 by giving due regards to the determination made herein above. Now, on that very basis, my lord, they filed a petition at page 68, my lord. That starts from 68. And with regard to this, my lord, they have filed it with regard to this. And to this, my lord, we have filed our reply, my lord. That should come afterward, but it has been annexed here prior to that at page 62. Where we have made specific avertment with regard to the property is concerned and everything, my lord. Allegation has been denied and opposing such and making statement that we were trying to take care of my father. Mother expired in 2019. We are taking, and he being influenced by some tantrics and all such things. Now, once the son and the daughter-in-law to be out of the house. So what I'm on, my lord, on this very basis, my lord, at paragraph 9 of my petition, kindly see, my lord, this is, I've stated this on oath on the basis of records. Paragraph 9 of my petition, page 6, my lord. The petitioner has filed a detailed written objection through counsel on 21/2026. Upon such filing, the petitioner was informed that the next date of hearing would be notified. No oral hearing thereafter took place, no inquiry was conducted, and no opportunity was afforded to the petitioner to advance submissions. 10. That notwithstanding the above, the tribunal proceeded to pass the impugn order recording that it had heard the learned counsel for the applicant and the learned counsel for the respondents, and therein after directed eviction of the petitioner with police assistance, my lord. The being aggrieved, my lord, this petition, my lord, will kindly come to the impugn order. That is at page 16. 12. I'm sorry, 12, my lord, 12. It's a long order, my lord, wherein my part of the case is never been discussed also. I was not heard in this case. No inquiry was there. Operative portion, my lord, will kindly come to, my lord. Yes, page 15, my lord. I have been directed to evicted, my lord, within 1 month, my lord. And order date is 29 January 2026. This is the order which we have challenged under 227. Kindly take up the, my lord, this act once, my lord. What is the law with regard to this? Now, the eviction order has been passed against the son and daughter-in-law also. The daughter-in-law doesn't come into the picture under this act, my lord. If I read it, my lord, we'll kindly see. Children, my definition part 2. Children include son, daughter, grandson, granddaughter, but does not include a minor. Maintenance, my lord, this has been there. Parents means father, mother, whether biological, adopted, or stepfather, stepmother, as the case may be, whether or not the father or mother is a senior citizen. Now, relative kindly come to, my lord, means any legal heir of the children, senior citizen, legal heir of the childless senior citizen, who is not a minor and in possession of and would inherit his property after his death. So his son may come in, but his daughter-in-law doesn't come in. Eviction against the daughter-in-law also. Now, my lord, will kindly see section 5. This is very important, my lord, because this honorable court directed him to file an appropriate application under section 5. An application for maintenance under section 4 may be made by a senior citizen or a parent, as the case may be, or if he is incapable by any other person or organization authorized by him, or the tribunal may take cognizance suo motu. Now, 2, my lord, will kindly see. The tribunal may, during the pendency of the proceeding regarding monthly allowance for the maintenance under this section, order such children or relative to make a monthly allowance for the interim maintenance of such senior citizen, including parent, and to pay the same to such senior citizen, including parent, as the tribunal may from time to time direct. 3 is very important. On receipt of an application of maintenance under subsection 1, after giving notice to the application to the children or relative, and after giving the parties an opportunity of being heard, hold an inquiry for determining the amount of maintenance. That inquiry has been defined under section 8, my lord, you can see. In holding an inquiry under section 5, the tribunal may, subject to any rules that may be prescribed by the state government in this behalf, follow such summary procedure as it deems fit. There is no rule as such, my lord. So, my lords, the second one comes into tribunal shall all the power of a civil court for the purpose of taking evidence on oath and enforcing the attendance of witness and of compelling the discovery and production of documents and material object for such other purpose as may be prescribed, and the tribunal shall be deemed to be a civil court for all the purpose. Now, my lord, there is no evidence, my lord, no inquiry itself. My lord, specific avertment at 9 and 10, that we have filed our written statement on 21/2026. My colleague has been informed that we will notify the next date. There is no next date. 29/1 comes the impugn order, wherein it reflects heard both the sides. So under these circumstances, my lord, tomorrow, if this honorable court doesn't stay this order or a status quo order is not been passed, and the lower record will speak in volume. If I have stated anything, my lord, which is contrary to record, will dismiss my case and impose cost on me. My lord, on affidavit that I have sworn in, kindly see the paragraphs I have put in on record. Paragraph 9, 10 are true to my information derived from records. So without inquiry, my lord, an order has been passed for eviction. Now the law has changed, my lord, with regard to this last judgment to the Supreme Court of 2025. The copy of that, sorry. This is a judgment with regard to the same act of 2025 March reporting, my lord, March 27. The relevant para is from 31, my lord. May I read it, my lord?
Yes.
The provisions of Senior Citizen Act nowhere specifically provides for drawing proceeding for eviction of person from any premises owned or belong to such a senior person. It is only on account of the observation made by this court in so and so, that is a 2015 judgment, my lord, that the tribunal under the Senior Citizen Act may also order eviction if it is necessary and expedient to ensure the protection of senior citizen. The tribunal thus had acquired jurisdiction to pass orders of eviction while exercising jurisdiction under Section 23 of the Senior Citizen Act, and which otherwise provide for treating the sale of the property to be void if it is against the interest of the senior citizen. The aforesaid decision was followed by this court in so and so. However, even in the aforesaid case, the court has only held that in a given case, the tribunal may order eviction, but it is not necessary and mandatory to pass an order of eviction in every case. The appellant tribunal has not recorded any reasons necessitating the eviction of so and so, or that in the facts and circumstances of the case, it is expedient to order eviction so as to ensure the protection of senior citizen. In our, it was complied with, my lord, it was interfered with. Here, my lord, if your lordship goes to the impugn order, my lord, there is allegation from the father side. There is negated by the other side, the son, my lord. And these allegations are true or false is been subject of inquiry, and that can be ascertained during evidence. And where I get the right to cross-examine and elicit the truth, my lord, which has not been done in this case. So under these circumstances, my lord, 29/1 was the last order, my lord, and the last date is tomorrow, my lord. And if it's thereafter, I will be evicted, my lord. Under these circumstances, I pray with folded hands before this honorable court to call for the records. It will speak in volumes. And thereafter, my lord, till that receipt of the records, my lord, status quo order may be granted, my lord. Otherwise irreparable cause, my lord, where I will go, my lord? This is sum and substance of my argument, my lord.
Okay, Mr. Kumar?
My lord, may it please your lord. This is one of the first case in Assam
Mm.
where the senior citizens have act has been invoked in this case. There is one suppression of order of the first order of this court has placed that order, how the maintenance tribunal was constituted in terms of this case. Because the first argument was that there was no tribunal, because this court has the occasion to deal with this case. Because this was the first case in which the tribunal were constituted. This has not been annexed with the present proceeding, madam. Your lordship will kindly look into that order, my lord. After this order, my lord,
Appellate tribunal. Tribunal, this is appellate authority, Dada. It is tribunal kotha koise no. This order is with regard to, my lord, formation of tribunal, not appellate authority under 16.
wait, I'll come to that. Let me.
There is no suppression. I will never say so.
So you have not annexed this order. So
No.
after this order, my lord, we are
No,
wanted
no,
back to the
yes.
tribunal. In the tribunal, my lord, that order is part of the record. That tribunal said that this tribunal has no power of eviction. And since I am getting pension and all, I'm not entitled for monetary maintenance. That's why the tribunal doesn't have the power of the eviction. Then we came again before this honorable court, citing the judgments of the honorable Supreme Court and the law of the country, that the tribunal has the power to order eviction. That order, your lordship will kindly look into it. It's a detailed order.
Suppression.
The mark.
This tribunal-
42, my
the tribunal they take some dismissal.
43. Of the orders that. This deals with the entire case history. Your lordship got it, page 43.
Yes.
Now your lordship will see the facts of this case. Whether this son and daughter-in-law deserve any sympathy. Your lordship will see the paragraph number 2. The petitioner herein is a senior citizen aged about 70 years. Earlier, the petitioner served as an estate officer under the Secondary Education Board of Assam Seva and retired in the year 2015. It is the case of the petitioner that the petitioner owns a plot of land measuring 3 kata situated at Gauhati under village Sohar, Kulbari, part 1 of Mudra Ulbari, in the district of Kamrup, Metro, Assam. According to the petitioner on the said plot, the petitioner constructed a D+2 residential building only and exclusively financed from his own resources and also by availing loan which he had fully repaid. It is his allegation that the respondent number 4 and 5, who are his son and daughter-in-law, were living with him in the said house and they subjected the petitioner to physical and verbal assault and has also abused and harassed him. It is his further contention that the aforesaid backdrop of harassment he was forced to take refuge initially in a hotel and subsequently he is living in a rented premise by paying a rent of ₹10,000 per month. It is the further contention that the vehicle of the petitioner bearing registered number AS01VJ7026 has also been taken over by the respondent number 4 and 5. In the aforesaid backdrop, the petitioner submitted an application under the Maintenance and Welfare of Parents and Senior Citizen Act 2007 before the District Social Welfare cum Maintenance Officer, that is the respondent number 3, praying for maintenance and eviction of his son and daughter-in-law from the house as recorded herein. However, the said application regarding maintenance was rejected on the ground that the petitioner, being a retired government employee, has sufficient means to maintain herself.
Okay.
So far,
Mr. Kumar,
yes, sir.
we are not finally hearing and disposing of this.
No,
case,
no,
no?
I'm against the interim order because it is an appealable order under section 16 of the Maintenance Act. Because since it is an appealable order.
No. First, you tell me whether inquiry was conducted before passing this impugn order.
Absolutely.
My lord, admitted facts need not be inquired into because it is admitted that this.
No, whether the act provides for.
Yes, sir.
Where?
I'll come to the judgments of the Honorable Supreme Court.
Whether it is provided in the act.
No.
No, madam, this is not an eviction under section 5. This is an eviction under section 27. It's a summary procedure. Summary procedure. And your lordship will find from this. That's why I'm reading this judgment to show that they have admitted that this is the property belonging to the father and I have been displaced.
Mm.
They have not been able to produce any document to show that they own the residential building. So if they can't show, if the the property belongs to me and I have placed my jamabandi and all the land records of the building and the documents, and from that the tribunal is satisfied that I am the owner and these people are unauthorisedly depriving the senior citizen from the property. They are not only depriving, they have taken all my land, everything from the building. And I am staying in a house now outside I can't even enjoy my. That's why I placed the judgment of this Honorable Supreme Court, Your Lordship, because any interim order passed today will cause prejudice to them. Because what I can do, I will not cause any injustice to my son or my daughter-in-law. I will pay for the rent of their staying outside, but not in my house. This situation has become too much of acrimonious now. And they just want to delay this proceeding on the ground of technicality. That Your Lordship will not address, considering the background on the which this order has been passed by this Honorable Court and how the matter has been dealt with by the cabinet. Because once an order has been passed under Section 27, whether rightly or wrongly, that is another aspect that they have to go to the appellate tribunal. Because earlier under Section 16, there was an impression that only the senior citizen can go for an appeal. But now the law has changed that Section 16 has been interpreted in such a way judicially that even not only the children, even the relative, suppose I don't have children, I give a relative, then they also can file an appeal under the under Section 16. Today, if they say that there is no appellate tribunal under in the state of Assam, then like in our own case when it first came, Your Lordship can always direct the state to constitute a tribunal and they will move the tribunal. But so far, Your Lordship will not disturb the eviction orders because the Supreme Court has time and again has held that this senior citizen people enough is enough.
When the appellate tribunal is not constituted by the state,
Yes.
so do we not entertain this civil revision
No,
petition
your lordship will can entertain the civil revision petition
under
but-
Article
but no
227?
but no interim at this stage, because that will cause prejudice to the senior citizen. That I will prima facie satisfied that why they are not entitled for the interim order. Even if your lordship entered in this application, that's
No. We are not disposing of the matter on merit
No, no,
today.
but-
We are only
no,
considering the pair.
Your lordship will look into the matter. But your lordship will not stay the eviction order. Let them give an undertaking before this honorable court that within the next 2 weeks they will vacate the premises and your lordship will fix a rent. A son who has kicked out his father, whether this court will take the side of the senior.
My lord, the impugned order 29-1 has been passed, my lord. Today is 27, my lord. So kindly look into it, my lord.
Okay, we'll
Deeply
see.
obliged for that.
Number 10.
Lordship, in this case, my petition under Order 13, Rule 10 was rejected. The order is at page 32. Lordship, here I have to concede that there is nothing wrong in the order as such, Your Lordship. Because coming to the order at page 32, the court has rightly observed that when the parties aver that without any, I have filed the petition for calling of records from the circle office, Your Lordship. But in my petition before the learned trial court, I have not averred the fact that I have applied for certified copy and those were denied to me. That was not the fact before placed on record by the petitioner. Lordship may peruse paragraph 6 of this petition, Your Lordship, at page 5 of the instant CRP. That the petitioner states that she filed the petition calling for the trace maps so that she could exhibit those at the stage of DW. Be it pertinent to mention here that the defendant tried to obtain the certified copies of all the trace maps. However, the concerned office refused to issue such copies, citing the pendency of litigation, and only under such circumstances the petition under Order 13, Rule 10 was filed. Though the fact of non-issuance of copies of trace maps of Padmapukuri village was inadvertently not mentioned in the petition, but the said fact was placed during the oral submissions. Now coming to the order, Your Lordship, which has been impugned at page 32, the court says that the fact that she has in fact tried to obtain certified copies is not mentioned in the petition. And at this stage,
Which part of the order it has
order starts from page 32.
Mm.
At page 33,
Mm.
last paragraph onwards, Your Lordship, from the plain reading of the provision,
Mm.
it appears that the that application made under this rule be supported by an affidavit showing how the record is material to the suit in which the application is made, and the applicant cannot without unreasonable delay or expense obtain a duly authenticated copy of the record of such portion thereof as the applicant requires, or that the production of the original is necessary for the purpose of justice, but the petitioner defendant have not shown why they cannot without unreasonable delay or expense obtain the such documents. Both the parties are at liberty to produce any documents on record and adduce an evidence at the stage of evidence, but at this stage the court have not found it necessary for the court's intervention. So it was rejected at this stage. There is nothing wrong, Lordship. However, if I may withdraw or Lordship may dismiss this, I may be permitted to file appropriate petition at the relevant stage after trying to apply for certified copies if that is not handed over to me. The suit has just begun and I am the defendant. I will require these documents at the stage of DWs. Admittedly, I did not aver in my petition that I have applied for certified copies.
No,
Those are-
Mr. Mukherjee, you see, the trial court has given you the chance to produce the documents
Lordship,
to prove their case,
Lordship,
genuine chances.
Lordship. The difficulty is, Lordship, I have applied for certified copies. Those were not handed over to me. As such, after rejection of this petition, if I again file a similar petition on the same line, Your Lordship, at the time of DWs, it will be rejected because the issue has already been decided by the court, Your Lordship. That observation only, Your Lordship, because if I may try to obtain certified copies and that is not given to me again, then I may approach at relevant stage whenever my evidence is there, Your Lordship, at the stage of my evidence of the DWs.
Okay. With that observation, we will dispose of this petition. Next.
Number is 11.
May please, Lord.
Hmm.
Lordship will find the incident order at page 59. Order dated, my lord, 15/11/2025.
Hmm.
The petition for amendment filed by the plaintiff has been allowed, my lord. Lordship will find the operative part at page 61, paragraph 8, my lord. The learned trial court, my lord, adopted the liberal approach. Page 61, my lord, paragraph 8.
Hmm.
It is settled position of law that the court should adopt a liberal approach in granting amendment of pleading. However, the same cannot be granted.
So
in
at
contra-
what stage the case is pending there?
My lord, at the stage of SBPH, my lord, next date is, my lord, 9/3/2026, my lord.
At what stage?
9/3 SBPH, step before preemptive hearing. My lord.
Okay.
I am the, my lord, defendant.
So the issues have not been framed yet.
No, my lord. Amendment sought for, my lord, challenging the, my lord, power of attorney. The suit is, my lord, challenging the sale deed executed by the defendant number 1 in favor of defendant number 2 through the, my lord, power of attorney order defendant number 3. The real controversy is as regards the, my lord, sale deed, not the, my lord, power of attorney, my lord. And the, my lord,
No,
the
how the nature and character of the suit will be changed?
because the, my lord, original real controversy is with regard to the sale deed, my lord.
Hmm.
They have challenged it because their pleaded case of the plaintiff is that the, my lord, though I am the co-sharer, but I have no sellable right to sell the, my lord, suit land to the, my lord, defendant number 2. In fact, my lord, section 44 of the TP Act, my lord, even the co-sharer, my lord, co-owner can transfer his share.
Hmm.
And they have not sought for any, my lord, decree of right title interest regarding suit land. They only filed the suit for,
Okay, let notice go and.
my lord.
Heard Mr. R. Sharma, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the order dated 15/11/2025 passed by the learned civil judge senior division Lakhimpur in North Lakhimpur entitled foot number 1 of 2025. It is to be noted here that by the impugned order dated so and so, the learned trial court has allowed the amendment of the plaintiff after filing of written statement by the
Defendants.
present petitioners. Where is the petition and the documents placed on record? Let notice also peruse the impugned order dated 15/11/2025. Issue notice to the respondents returnable in 4 weeks. Step by registered speed post and also by usual process within a week from today. List the matter after 4 weeks, interim pair of the petitioner will be considered on next date, returnable date.
Stay, my lord. Obliged.
Number 12.
May I please, your lordship?
Yes.
My lord, here in this revision, we are the defendant in the suit.
Okay.
The the plaintiff filed a suit for rejectment as well as for other reliefs.
Mm.
The original defendant, Nami Boro,
Mm.
she filed a written statement and contested the case. After her death, the present petitioner as defendant has appeared and they filed written statement and a counterclaim. And when the counterclaim is filed, a right has been accrued to the plaintiff to file written statement on the point that in the counterclaim is made. The counterclaim is to be treated as a plaintiff. So far, and the plaintiff has a right to file written statement of his file. But here in this case, your lordship can see in my written statement that is in page number 43.
Yes.
Page number, your lordship can see page number 62. 43, yes, yes. Yes, yes. Sorry, 43. Here in this written statement, I made denied the various facts, and my true facts are mentioned in paragraph number 22, page 48. True facts. Till paragraph number page 57, paragraph number 50. Therefore, in my written statement, the true facts of the defense is from 22, paragraph number 22 to paragraph number 50. And my counterclaim is from paragraph number 51 to 56.
Yes.
And the plaintiff can file written statement on the counterclaim that was stated in paragraph number 51 to 56. But they have filed a written statement against the statement made in my written statement from true facts. That is not permissible. Because
Only on counterclaim.
only on the counterclaim. They can file a written statement only on the counterclaim, not the statement I have made in the written statement.
Okay.
But they have filed a written statement on the statement made by me in the counterclaim. On the true facts. Therefore, I filed a petition before the trial court to strike off the pleadings that were filed by them so far true facts is concerned.
Okay.
Yeah, and the learned trial court has rejected my petition on the ground that if this is done, the proceeding will be delayed. And that is
Where is that
the
observation?
page 138, your lordship.
138.
138, paragraph number 15.
Okay.
Order 6, Rule 16, I have quoted. Upon reading the aforesaid statement of provision of law, that the pleadings may be struck out only unnecessary, scandalous, frivolous, vexatious, or may embarrass the delay in the trial, the abuse in the process of the court. However, on going upon the petition filed by the petitioner defendant, it appears that although they have claimed the pleading in the plaintiff in the written statement of the counterclaim are frivolous, vexatious, but they have also failed to show on what ground those pleadings are to be struck out. They have also failed to show the pleading may cause the delay in trial of the and the abuse of the process of court. On my consideration base, the petition is rejected. But that is not the ground. It is the when the written statement or pleading can be struck out, it must be scandalous, vexatious, or in the abuse in the process of court. Order 16, Order 6, Rule 16C, abuse in the process of court. This is the abuse in the process of court. And the Order 6, Rule 16 petition can be filed at any stage of the proceeding.
Okay. Abuse of the process of the court.
Yes. There is the abuse in the process of the court. Because what they cannot file a written statement on my true facts, they have filed. When I filed a petition for striking out, the court says that it is not the abuse in the process of court. But it is the abuse in the process of court. Because they have right to cross-examine the defendant on this point.
So, where is the written statement filed by them?
That is in page number 81. Sorry,
81.
written statement filed by them. Filed by the plaintiff.
Yes, yes.
Yes. 62 years.
Page number
Page number 62.
62. And what are the paragraphs which are against the true fact?
Paragraph number 1, your lordship kindly read.
1.
1. The legal representatives of the defendant, namely so and so, filed a written statement and counterclaim in para number 22 to 50 have been placed in the statement of facts under the heading true facts, and based upon the same, the paragraph number 51 to 56 has laid their counterclaim, and accordingly this written statement is filed to deal with counter those statements of fact and heading the true facts and the counterclaim based upon the same as stated in the written statement and counterclaim. Whether your lordship is to see whether on the true facts that I have stated, whether they have any right to file written
No,
statement.
that's all right. They have no right.
They have
But,
not.
you show me the paragraphs of where they have filed a written statement against the true facts.
Paragraph number 20 from 6 onwards.
6 onward.
Yes.
Okay. 6 onward up to
Up to
20.
up to 25.
25.
Yeah.
And your petition is at page number
My petition is page number 116.
116.
Paragraph 10, you also can see.
Paragraph 10. Okay. Okay, we'll see. We'll pass the order. If necessary, we will dispose of the petition today itself.
Yes, my please, Your Lordship. Impugn order is page number 58, Your Lordship. Prayer for amendment the written statement, Your Lordship. Annexure, Your Lordship.
Page number? Page number?
Page number 58, Annexure E.
So after 7 years of filing of the case, the amendment petition was filed. And at the stage of cross-examination of the witnesses
Lordship.
of the plaintiff. So how do you explain due diligence?
Actually, at the concerned council, Your Lordship, letter filed it, Lordship.
Hmm?
And to the present Lordship, the proceeding of this case also suspended, Your Lordship. There is another appeal pending before the district judge Dhubri, Your Lordship, regarding the valuation of the case.
No, can that be a ground for delayed filing of the amendment petition?
No, actually not ground,
Hmm?
actually. There is a negligence of the council, Your Lordship. Actually, this is the
For how many years the proceeding was languishing before the appellate court? In district judge Dhoguri, in the court of district judge Dhoguri?
district judge Dhubri 2025, Your Lordship. That's
25.
another issue, Your Lordship, not this issue.
25. For how
On
many years it
valuation
was
of
there?
the suit value, suit, Your Lordship. Valuation of the title suit, Your Lordship, on that issue. Separate issue, Your Lordship. And here, Your Lordship, amendment of the written statement, Your Lordship. Only on the point that the defendant number 3 purchased the suitland from on Delsra Dali, Your Lordship, by right registered sell it, Your Lordship. There is a delay, Your Lordship. My prayer, Lordship, notice may kindly be issued, Your Lordship.
Since when the case was pending before the district judge?
Actually, it's, I have no full information, Your Lordship. 2025, Your Lordship.
When the suit was instituted?
So 2017, Your Lordship.
2017.
Lordship.
17. And when the district
page
judge has
number-
remanded the case to the trial court?
Trial court is Munship, Lordship, Bilaisipara, Your Lordship.
Yes,
Lordship.
when it was remanded? Hmm?
Lordship. Annexure C1 and C2, Your Lordship. Page number 43, Your Lordship.
Annexure C.
C1, C2. It was first time, Your Lordship, and impugn is second time, Your Lordship. This is a amendment for WS, Your Lordship, that was rejected, Your Lordship, on 6th March of 2019, Your Lordship. Page 47 order, Your Lordship. Petition is page number 43, Your Lordship.
No, you have submitted that the case was pending before the Court of Learned District Judge, Gauhati.
No, Lordship. There is another appeal on suit value, Your Lordship. I have not annexed those documents, Your Lordship. Successfully got the information of our mobile phone, Your Lordship, on the issue of suit value, Your Lordship. That I have
It
not
appears
annexed.
that this suit is pending before the civil judge Bilaisipara from the very beginning.
Our case is
Mhm.
pending before the now Civil Judge Junior Division, Bilaisipara, Your Lordship. That evidence is to Your Lordship.
Mhm. You show me what illegality is committed by the learned trial court in passing the impugn order dated 9/7/2025. Because a detailed order was passed by the learned trial court,
Lordship.
and on 3 grounds the learned trial court has rejected your prayer. One is delayed over 7 years.
Listeners.
Number 2, departure from the original defense and prejudice to the plaintiff and derail the progress of trial. Which of these 3 grounds, according to you, are illegal and arbitrary?
Lordship. Ground number 2 and 3, Your Lordship.
2 and 3.
Departure from the original defense, Your Lordship.
But the one is sufficient to reject your petition. Where is the due diligence? When did you file the written statement before the trial court?
Lordship, on 9th August 2017, Your Lordship.
2017. Okay. We'll pass the order.
Item 21 for
Oblige, Lordship. Yes, ma'am.
Authorised matter, item 21.
May it please your lordship. As per office note dated 25/2/2026, your lordship. The postal is
Job is completed?
not completed, your lordship.
Not completed.
It has been shown as addressee left. I may be allowed to take steps to substitute service, your lordship.
Substituted mode.
Yes, your lordship.
Heard, Mr.
J. Das.
J. Das, learned counsel for the petitioner, and Mr.
Lordship, I am appearing on behalf of Mr. K.K. Mahanto. Lordship, we have filed our wakalat number today for respondent number 1 and 2, your lordship.
Learned counsel, your name, please.
Gautam, your lordship.
Learned counsel appearing on behalf of Mr.
K.K. Mahanto.
K.K. Mohanto. Learned counsel for the respondent number 1 and 2.
1 and 2, your lordship.
1 and 2. The learned counsel for the petitioner submits that service in respect of respondent number 3 is yet to be completed. And he submits that he may be permitted to effect service by substituted mode. By paper publication?
Paper publication.
Paper publication. Pair allowed. Recessal lays the matter after 3 weeks.
Intend to continue, your lordship.
After 3 weeks. And fixing the matter for paper publication on
16th of March, your lordship.
16th of March. 16th of March. And after effecting service by substituted mode, the petitioner shall file an affidavit before this court and enclosing the relevant papers. This is the matter after on. No, there shall be 2 dates.
On 25th.
20th. And for paper publication, 16th of March.
Intend to continue, your lordship.
Interim order shall continue.
Deeply obliged.
Item 22.
None appeals for the petitioner on call. Order dated 16/2/2026 and 26/5/2025 indicates that the petitioner remain absent. No, the petitioner remain unrepresented on those 2 dates. Today also the petitioner remain absent. The petitioner remain unrepresented. In view of above this CRPIO that number 364 of 2023 stands dismissed for non-prosecution.
23.
Lordship, this revision petition is preferred against the judgment dated 19/6/2024, asked in title appeal so and so. They have made appearance, sole respondent has made appearance, filed their written objections. That written objection was not on the record, that has come today.
But it's not on
It has come in record today.
Pardon?
It a written objection filed by them, filed by the sole respondent, was not on record. It has come on record.
When it was filed?
It was filed. It is shown to be filed on 19/1/2026. Yes.
10 February. Okay. Heard Mr. Bhagavati, learned counsel for the petitioner. And also heard Mr. Learned counsel appearing for the respondent. Mr. Bhagavati submits that those services completed.
Service complete.
Those services completed in this matter. The objection filed by the respondent herein is not placed on record and therefore the matter is listed under the column order. Accordingly, it is provided that receipt shall list the matter in the admission column and take the objection filed by the respondent herein with the record. List on-
Interim
list
order.
after
This on 25th March.
25th March. Interim order pass earlier shall continue.
May we fixed on 26th,
March.
not on 25.
Okay, 26.
27.
Okay, Thursday.
27.
Lordship, interim order.
Yes, order.
Item 24.
May it please your lordship. Your lordship, as per the last order, service report is awaited, your lordship. Kindly fix the date, your lordship.
Actual side, our way of respondable was 5 in this case.
1 to 5
Yes, Lordship.
for all the respondents.
No, there are two more. They have
2
not-
more.
Yes.
Okay. Heard, miss, your name, please.
S.C. Mutaja on behalf of S.C. Mutaja on behalf of R. Chaudhary.
Learned counsel appearing on behalf of Mrs. R. Chaudhary, learned counsel for the petitioner, and Mr. R. Sharma, learned counsel appearing for the respondent number 1 to 5.
Yes.
1 to 5. Mr. Sharma submits that during the course of the day, he will file his power. One to 5 or 1A to 1E?
1A to 1E.
One, yeah.
Okay, 1A to 1E.
Lordship, there is some mistake in the names of it. One B, it should be Asif Afan Chaudhary. And one B will N-O-U-R-I.
Inform her so that she can file one petition or interlocutory application. So you want to take a fresh step upon respondent number 2 and 3?
Yes, your lordship.
The learned counsel for the office note dated 19/1/2026 indicates that service report in respect of 2 and 3 have been no service report in respect of respondent number 2 and 3 have been received by the section till date. The learned counsel for the petitioner submits that she will take fresh step upon the respondent number 2 and 3. Accordingly, it is provided that step be taken by speed post and also by usual process within a week from today. This is the matter after 4 weeks.
Obliged.
Paragraph 26.
As per the office note dated 23/2/26, the service on sole respondents is completed. Lordship.
You have all the respondent.
Yes, madam.
Okay. Record receipt?
Yes, yes, sure.
Okay, we will list the matter for hearing then.
Yes, madam.
Heard Mr. Bhattacharya, learned counsel for the appellant,
If I may, madam.
and Mr. Imtiaz for the respondent. It is submitted at the bar. In this matter, service has already been completed and the records have been received from the learned courts below. And the matter may be listed for admission. No, sorry, for hearing.
My lord, sometime in the month of May, a date may be fixed, madam. That is my only prayer.
So
let it be
let's
on-
say this is of 2025 matter.
Yes.
They will list it in usual course. Will not fix any date.
Yes, yes, madam.
Rest is a list the matter for hearing in usual course.
I will.
27.
With reason of it. In this matter, as per postal track consignment report, the service has been complete.
Upon all the respondent.
Hmm. The notices has been issued, but in the office note dated 21/2/26, as per the postal consignment report, it is showing that item has been delivered to the addresses.
Okay. I guess. Consignment report J and T. Appellant. Office note dated 21/2/2025 indicates that as per postal track consignment report, item have been delivered to respondent number 1 to 5 and 8. 5 and 8. And in view of the said office note, notice upon respondent number 1 to 5 and 8 is thence completed. But no one entered appearance for the said respondents. Lays the matter for hearing in usual course.
Obliged.
So the record has been received from the trial court? Okay. Yes.
Obliged.
Item 28.
May I please, my lord? My lord, as per office note dated 16/2/2026, service on the other respondents complete except the respondent number 2, my lord. Respondent number 2 has returned back, my lord, which says that no such person found. So I may be allowed to take further steps on respondent number 2, my lord. Office note dated 16/2/26, my lord.
You want to take fresh step?
Because 2 has returned back, my lord, as the person is not found as per the
That's
postal
all right. You have to take fresh step upon respondent number 2.
2.
Heard Mr. Gupta, learned counsel for the petitioner. And also heard Mr. Learned counsel for the respondent number
326.
326. Mr. Gupta, learned counsel for the petitioner, referring to office note dated 16/2/2026, submits that service upon respondent number 1 and 7 have already been completed. And he also submits that he may be permitted to take steps upon respondent number 2 if fresh. They are allowed step be taken by speed post and also by usual process within a week from today. Place the matter after 4 weeks.
Obliged.
Item numbers 29 and 30.
Please, your lordship. IA number 3036, that's for condonation of delay in preferring a review. In fact, the major chunk of the delay is because we were pursuing an SLP before the Honorable Apex Court. And the Honorable Apex Court eventually said that we should instead file a review. That order is, of course, in the review application. In
What
fact,
is the limitation period for review, filing review?
Yes, sir. We have filed a reply also.
You will file a
Yeah, I
reply.
file a reply. Let it be for listed for admission hearing.
Or
on,
you will file a reply.
No,
they've already filed.
They've already filed. Okay.
Let it be listed for hearing for the application, Your Lordship. On 24th of March.
24th of March.
Yes, sir. It will take some time, that's why.
Heard Mr. Decker, learned counsel for the applicant, and Mr. P. Chaudhary, learned counsel for the respondent number 127. 127. None appears for the respondent number 8 to 10. It is submitted at the bar that the objection has already been filed by the respondents, and the matter may be listed for hearing. Accordingly, it is provided that recess shall list the matter for hearing on
24th.
The delay is yet to be condoned. So should it come up for orders
on this
instead?
petition.
Because delay cannot be condoned. I have shown the record also.
So
Well,
I was just wondering if your lordship will have it for orders.
No,
because
you cannot have
Here-
it. Incorrect statements have been made. That's why I'm telling you. They have.
No, hearing on this I,
Yeah,
I-
yes, I only. I'm saying.
not
Here-
on the main matter.
No, no. I only.
Obliged.
That is yet to be.
Yes, sir. Only the I.
Obliged.
30 would not there. 29. 30 I think is fresh matter. 30.
29.
No, 30 is a fresh matter, I think. But 30 they have filed a review date now only after 6.
30, I'm not appearing, Lord. 30 is also a review filed by another bunch of,
After
another bunch of.
with the SLP, they came again and review. Yeah.
Actually, perhaps Mr. P. Upadhyay is appearing.
He is appearing here also, I think, for responding 8 to 10.
8, 9 and 10 SP Upadhyay.
Okay.
He's also filed a review.
No, this is a separate application.
This is separate. No, we are not there.
Again, the same.
None appears for the applicant on call. List the matter after 2 weeks.
Yeah.
In the event of subsequent non-representation of the applicant, appropriate order shall follow.
24th.
24th March.
No, this in this
No,
matter we
I-
have
I
not
only
fixed.
the I- Not, I only the I.
Obliged.
Why not 30? I don't miss 30. 30.
Okay. Later on, Mr. P.P. Upadhyay, learned counsel for the applicant, appeared. This interlocutory application under Section 5 of the Limitation Act 1965 is prepared by the applicant for condonation of delay of 378 days in preparing the review petition filed under Chapter 10 of the Gauhati High Court rules read with Order 47, Rule 1 and 2 of the Code of Civil Procedure. Let notice be issued to the respondents, opposite party, returnable in 4 weeks. Step by speed post and also by usual process within a week from today. List after 4 weeks. এইটোতো হেৰিয়ে হোৱা নাই পাৰ্টি পিছত দেখা যাব
May I please your lordship, this is IA for condemnation of delay of 135 days in preparing the civil revision, my lord. My lord, the notice was issued. My-
Is there any objection in condoning delay?
135 days. my lord.
Let the matter come up on admission for after 2 weeks.
First,
It has already been executed technically, Lordship. There is nothing remains in the matter.
delay, my lord, first we condemn, then my lord, it may come for admission. 135 delay, there is a my lord, medical ground where he was suffering from schizophrenia in that point of time. Paragraph 5, I have stated and I have.
Schizophrenia certificate was given by the civil hospital, not by any mental hospital. Not by any specialist.
Heard Mr. Anhock, learned counsel for the petitioner, Mr. Footer for the respondent. List the matter for hearing on 26 March.
Well,
Heard that
civil revision has not been, my lord, registered. Revision has not been registered.
that's all right. Hearing on this application.
Oh my, this,
But we have some urgency because the execution case is pending and partly execution has been made. Remaining, my lord, this
First date? First week of March?
12th,
10th,
10th March.
32 and 33.
My lord, in item number 32, my lord, the other side has filed one objection. I have checked the record, my lord, as per office note dated, my lord, 25/2, that objection is not on record, my lord. Office note dated 25/2, my lord.
Okay, let it be on another date. In
Along
the
with the
meantime, Resti will
objection,
take
my lord.
the objection.
Item number 32 and 33 are together.
Yes,
In both the matter, objections filed.
no, in item number 32, objection is filed. 33 is, my lord, MSC appeal after
Okay.
condemnation delay, first time listed, my lord,
Okay,
but
that is a different matter.
different matter.
But the advocates are same.
Advocates are same.
Heard Mr. Gupta, learned counsel for the applicant, and also heard Mr.
ALE on behalf of JK.
A. Ali, learned counsel appearing on behalf of Mr. J. Kolita, learned counsel for the uh, opposite party. For the opposite party. Mr. Gupta submits that the the respondent herein have filed their objection, but the same has not been placed on record. And as such, Mr. Gupta submits that the matter may be listed on some other day, directing the registry to take the objection filed by the respondent hearing. Where allowed, registry shall list the matter on
Any date, my lord, if sorted possible. my lord. Yes.
9th of March and take the objection filed by the respondent hearing with the record. In item number 33,
My lord, I am for the claimant, but the copy of the appeal memo is not served, my lord. Here the delay, earlier delay was there, my lord, in MSC appeal, my lord. Delay condoned and thereafter it was first time listed, but the copy is not served, my lord. So it may come up other day along with that, my lord, on the same day. And in the meantime, they may serve the copy, my lord.
you are for the respondent.
Respondent claimant, my lord.
Heard Mr. Learned counsel appearing on behalf of Mr. J. Kolita, learned counsel for the appellant, and Mr. Gupta for all the respondents.
No, I'm for only, my lord, respondent number 1 and 2 perhaps.
1 and
2, my lord.
1 and 2. Here, delay is condoned.
Delay condoned, my lord.
So we have to admit the matter today.
Yes, and then the
This appeal under section 173 of the MD Act is directed against the judgment and award dated 22/8/2023 passed by the learned member. MSCT number 2 Tinsukia. No, learned additional member 2 MSCT Tinsukia in MSC case number 38 of 2015. Whereas it is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed respondent number
that insurance company is directed to pay compensation of 15,37,000.
directed the respondent number 7, the National Insurance Company Limited, to pay a sum of rupees 15,37,000 being the compensation. Where is the memo of appeal and the grounds mentioned therein? Admit. Issue notice to the respondents. Returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number
1 and 2, my lord.
1 and 2. Since Mr. Gupta entered appearance and received notice, however, extra requisite copy of the memo of appeal be furnished to him during the course of the day. State upon rest of the respondent be taken by speed post and also by usual process within a week from today. Rest shall call for the record from the learned tribunal. List the matter after 4 weeks.
Obliged.
Item 34.
May I please, your lordship?
So respondent number 2 expired.
My lord, 1 and 3 complete, my lord. 1
Yes.
has already appeared. 3 received by wife, my lord, as per 25 office
No,
noted.
that's all right. In respect of 2, you have to implement the legal hairs.
My lord, I'll file substitution petition. I have been told by my learned brother that he will provide me the details of legal heirs.
Details by Monday.
Okay. Part Miss S.S. Zia, learned counsel for the petition, or no, for the appellant, and Mr. Harda, the learned counsel for the respondent. Office note dated 25/2/2026 indicates that respondent number 2, the service report in respect of respondent number 2 has been received, and as per the report, the respondent number 2 suffered demise. Ms. Zia submits that she will file substitution petition. And that the learned counsel for the respondent undertakes to furnish the details of the respondent number 2. Accordingly, it is provided that recess shall list the matter after 2 weeks or 3 weeks.
My lord, in the IA, my lord, 5826.
No, here we'll grant you 2 weeks or 3 weeks.
3 weeks, my lord.
3 weeks.
And in the IA, my lord, 5826, my lord.
Yes, any objection in this side?
Lordship, the IA may continue till the next date, my lord.
My lord,
Because one of the respondents has died.
No interim order has been passed till date.
So one of the connected IA, the interim has been passed.
my lord, the IA, when the IA, this IA number 5826 was passed, at that relevant point of time, we have not received any notice from execution court, my lord. Thereafter, we have filed another IA in this particular IA, 176 to the. There, my lord, we have annexed the notice of execution proceeding, my lord, and it was state. Order dated, my lord, 29/1/2026.
Okay, interim order passed in the IN number 176 of 2026. In RSN number 1 of 2026 shall continue. List after 3 weeks.
Obliged.
35.
May I please, your lordship? Lordship, this civil revision petition is basically for against the order passed under the application filed under Order 7 Rule 11, the rejection of claim, my lord, but no unserved notice has been received. My lord, it was earlier observed that interim will be considered in the next returnable date, my lord. My anxiety is that, my lord. My lord, it's a defamation suit, basically. The suit was of defamation based on a complaint made by the petitioner before the bank, my lord, before the higher authority. The respondent means they are the plaintiff. He is the banker, my lord, and the petitioner here is the customer of that bank. So he wants to renew his cash credit account, my lord, but this bank official, my lord, this respondent herein, he was denying, my lord. So citing some reasons, my lord. Thereafter, he made a complaint before the higher authority of the bank that this person is doing such and such things. So I could not therefore renew my cash credit account. That is the basis of this defamation suit, my lord. So, my lord, at page 23, this,
No, that's all right, Mr. Decker. You say services yet to be completed.
yes, my lord.
So, whether you have tracked consignment in the website of the postal department?
My lord, we cannot because it is in the domain of the registry, my lord.
But you can obtain the number from them.
Yes, that can be done, my lord.
Okay, heard Mr. Decker, learned counsel for the petitioner. Office note dated 25/2/2026 indicates that neither AD card nor unserved notice in respect of the respondent received till date. You have taken step on which date?
It was on filing. এইখনতে নহয়, এইখন ফাইলিং ন? এইখনে?
Okay. This I'll list the matter after
29/1/26. Steps has been taken.
after 1 week
Yes.
and track the consignment in the departmental website and put up an up-to-date office note in respect of delivery of the item to the respondent. List after 1 week.
Much obliged, my lord.
36.
Yeah, please, your lordship. Lordship, in this case, I am appearing for Mr. S.K. Ghosh. Lordship, this matter has been wrongly listed in the orders column, my lord. It ought to have been listed in the motion column. Because initially there was
There was an eye for condemnation of delay on the last location, it was announced. So
Hmm.
it's not a time of a motion. I'm appealing for the respondent number 1 and 2.
We finish for 3, 4, 5, and 6.
Okay, Mr. Ghosh is absent today.
He is, my lord, before court number 7, my lord. He is on legs in court number 7.
So we'll fix another date.
Yes, lord.
Heard. Mr. Bhardas, learned counsel appearing on behalf of Mr. S.K. Ghosh, learned conducting counsel for the petitioner, and Mr.
He's in Gupta.
E. Gupta, learned counsel for the respondent number 1 and 2. 1 and 2, and Mr.
Yes, not for
S. Nath, learned counsel for the respondent number 3, 2,
5, and 6.
3, 4, 5, and 6. 3, 4, 5, and 6. Recessal list the matter in the motion column on
9th March.
9th,
13.
13th of March.
Highly obliged.
Item 37.
Wait, please, your lordship. Lordship, as per the order dated 13/2/26, my lord, steps have been taken by speed post. And my lord, the justice service has been affected, my lord, justice service. I have filed the affidavit.
Hmm.
Affidavit is on record, my lord. They have received the notice.
Heard Mr. Kolita, learned counsel for the petitioner. Mr. Kolita submits that service upon the respondent number 1, 2, 3, and 4 have been impacted by dust remote, and an affidavit has been filed to that effect. Where is the affidavit? It appears that They have received the notice?
My lord, on 22-26, my lord,
They have received the notice on 22,
2-26.
22 to 26, but they remain unrepresented today. Recessor lays the matter on next Wednesday,
My lord, next Wednesday, 11 March, my lord.
11 March. Next Wednesday.
Holy, my lord, holy vacation.
What is holiday? 5th or 6th? 6th of March.
May I prefer interim, my lord, till 6, my lord, till 6th.
Let us say if somebody entered appearance,
Well-
interim order, interim pair of the petitioner will be considered on next day, 6th of March.
My lord. Highly obliged, highly.
Presence for admission. File number 13.
Lordship. Now, Lordship, this instant revision raises, Lordship, three core issues, Lordship.
Yes.
Yes, Lordship, this matter, this present revision raises three core issues, Lordship. The first issue is regarding the non-conclusive finding of encroachment by the estate officer. Issue number 2, Lordship, the learned appellate court below misread the pleadings and traveled beyond the records. And issue number 3, Lordship, the respondents failed to discharge the burden of proof. These are the three issues. Basing on which
Number 1 is?
issue number 1 is, Lordship, no conclusive findings of encroachment by the learned estate officer NF Railways.
Number 2?
Number 2 is, Lordship, the learned appellate court misread the pleadings and traveled beyond the records. This is the issue number 2, Lordship, which I have raised by way of this revision, Lordship.
And number 3?
Number 3, the respondents, Lordship, failed to discharge the burden of proof, Lordship. Failed to discharge the burden of proof. Therefore, Lordship,
Okay.
now therefore, Lordship, the impugned finding based on no evidence on misreading of pleadings and on jurisdictional overreach, the impugned judgment is not sustainable in law. Now, Lordship, this present case, Lordship, is based on the allegation of encroachment of a railway land. In law, the burden of proving such encroachment lies entirely on the authority or the person making such allegation. However, Lordship, no conclusive demarcation, boundary verification, or revenue certified correlation establishes that the sale deed, petitioner's sale deed overlaps with the railway land, Lordship. This is my first contention. And Lordship, my land, I being the person, on the strength of a registered deed of conveyance, Lordship, I have been possessing my Myadipatta land within well-defined boundaries, and the petitioner has been in continuous peaceful possession pursuant to the well-recognized title. No document of the State Revenue Authority's, Lordship, indicates that the petitioner is occupying the land beyond the sale deed boundaries. This is a very important pertinent point which I like to raise, Lordship, that no document from the State Revenue Authorities establishes or indicates that I have been possessing the land beyond the four boundaries of my sale deed, Lordship. Now, Lordship, the estate officer's order, Lordship, dated 17/2/21, contains no specific or quantified findings of boundary discrepancy, nor it
does it identify the alleged extent of encroachment? In absence of such foundational findings, Lordship, the subsequent allegation made by the respondent authorities in the written objection that the petitioner is not possessing as per cell deed boundaries, Lordship, remains mere pleading unsupported by evidence, Lordship. It's a mere pleading unsupported by evidence, and pleading with respect do not constitute proof. And for that, Lordship, I would like to cite a judgment of the Honorable Apex Court, which was reported in 1977 to SSC 49, Lordship. To SSC 49. Lordship, just one judgment of the Apex Court, Lordship. It is Sitaram Bhao Patil versus Ramchandra Nago Patil, Lordship. If Lordship, I have relied upon paragraph number 15, 16, 17, and 18 of this judgment, if I may be allowed to read it out, Lordship. Para number 15, Lordship. Now, in para number 15, Lordship, the decision of this court in Bharat Singh's case supervised that admissions have to be clear if they are to be used against the person making them. Admissions are substantive evidence by themselves in view of Section 17 and 21 of the Indian Evidence Act, though they are not conclusive proof of the matters admitted. Admissions proved are said in the decision to be admissible evidence irrespective of whether the party making them appeared in the witness box or not, or whether the party when appearing as witness was confronted with those statements in case it made statements contrary to those admissions. Counsel for the appellant submitted that the respondent,
Mr. Das, you say the proceeding before the state officer is a summary proceeding.
Yes, Lordship. Now the proceedings, Lordship, it was a summary proceeding as per the premises of the said act, Lordship. Now, Lordship, while the findings as
it was not a regular title, so
yes, but Lordship, now it was the submissions made by the respondent railways in the before the appellate court, Lordship, that I have made a admission in the paragraph number 3, predominantly on which the judgment was opined, Lordship, which was misconstrued.
No, it is not their contention. Their contention is that you have failed to describe the boundary properly in the
Yes.
in the written statement filed before the state officer. And the boundary given there, description of boundary in the said written statement is contrary to the boundary described in the cell date.
Yes, Lordship, in that aspect, Lordship, in my petition, Lordship, I have raised the point that it was the geographical description of the place, but nowhere in the said paragraph, Lordship, it mentioned about the boundaries of the cell date. And Lordship, insofar as the the contention raised by the railway authority.
No, you tell me whether the boundary and the geographical boundary is different.
Yes, Lordship, because Lordship.
How?
Because in Lordship, in the starting of my paragraph, if Lordship comes to the memo of appeal for the moment, Lordship, in my memo of appeal, Lordship, memo of appeal, Lordship, paragraph number, page number 90 of my petition, Lordship. Here, the location which in which the appellant said near the Patta plot of land is situated.
Paragraph number, page number 19 of your petition.
Yes, 90.
90.
90. Annexure 18 is my memo of appeal, and at page number 90 is the paragraph number 3, Lordship. It is the paragraph number 3, Lordship.
Yes.
Yes. Now, in paragraph number 3, Lordship, the location in which the appellant said Myadipatta plot of land is situated, on its eastern side, a broad gauge railway line is there, which was originated from Gauhati Kamakya railway station to Gwalpara station, then onwards to Bongaigaon and New Bongaigaon station, and so on. Such railway line has crossed the National Highway 37 through a railway overbridge built at the intersection point at Uttar Jalukbari, Gauhati. That single railway line is a single line track so far which has led from New Bongaigaon to Kamakya station via Gwalpara in 2002. After it was made fully operational, many passengers and good trains have been diverted to run through the said new railway line to ease out the excess load fallen on the main Guwahati-Rangia line and also to ensure more connectivity to many interior regions of the lower part of Assam. On the further southern side is the campus of the KK Handicap College, which is a pioneer and famous institution for imparting education of Sanskrit literature language in entire northeastern states. On the northern side of the upland land is a public road. On its northern side, the campus of the Cambridge Educational Trust is situated. Next to it, the same of the northern side, the state women shelter home under the Department of Social Welfare, Government of Assam is situated. Now, Lordship, in this paragraph number 3, Lordship, I made the reference to the Broad Gauge railway line, which has originated from Lordship, from Guwahati Kamakya railway station to Gwalpara station, then onwards Bongaigaon. First, I made the reference, Lordship. Thereafter, Lordship, while explaining the proximity of the said railway broad gauge railway line, I continued thereon. Lordship, in paragraph number 3, there is no categorical admission regarding my cell lead boundaries, Lordship. Preceding paragraph, Lordship, I made my pleadings that I purchased my land by registered cell deed. Exactly, I was mutated, Lordship. My possession was recognized by the state revenue authorities, Lordship. Therefore, while I see there is a broad gauge railway line originated from Kamakya station to New Bongaigaon station, I made the reference to that, Lordship. And Lordship, in that respect, Lordship, the contention was raised by the respondent railways that I have made a categorical admission of my cell lead boundaries, Lordship. But that contention was unsupported by any evidence. It was mere pleading, Lordship. On that respect only, I have relied on the judgment, Lordship, that the pleadings with respect do not constitute proof, Lordship. It has to be substantiated by admissible evidence, Lordship. That is my humble contention, Lordship. Lordship, in the judgment, Lordship, if I may be allowed to read out the rest of the paragraph, Lordship, for the moment. And
No, not necessary.
yes. Yes, Lordship, I have relied on paragraph number 15, 16, 17, and 18, Lordship, of the said judgment, Lordship. And now, Lordship, so far as the respondent railways are concerned, Lordship, they did not discharge the burden of proof to the allegation that the petitioner is residing outside the boundary of this cell deed, Lordship. The burden squarely lies upon them to prove such affirmative assertion, Lordship, with cogent and admissible evidence, but the instant matter, nothing indicates or show the same. Therefore, the learned appellate court below, Lordship, while passing the impugned judgment dated 12/2/2026, had reappreciated new factual points and without evidence and also unproved pleadings, Lordship. Lordship, I would like to cite another judgment in that respect, Lordship.
Unproved pleading means?
Lordship, the
It
pleading.
is your pleading.
No, Lordship. The contention regarding residing outside my boundary cell deed, Lordship, it was raised by the respondent authorities, Lordship. It was not me. I made the reference to the geographical location. Time and again, I have been submitting on that, Lordship. And that contention was raised by the respondent railway authorities that I have been residing beyond my cell deed boundaries, Lordship. And that was not substantiated by any admissible evidence. This is my contention, Lordship. On that aspect, Lordship, I would like to place one judgment, Lordship, reported in 2006 5 SSC 558, para number 8, 10, and 19, Lordship. Anil Rishi versus Gurbakh Singh, Lordship. Lordship, here I have relied on para number 8, Lordship, and para number 10 and 19, Lordship. Para number 8, Lordship, the initial burden of proof would be in the plaintiff in view of section 101 of the Evidence Act, which read as under section 101, the burden of proof, whoever desires any court to give judgment as to any legal right or liability dependent on the existence of fact which he asserts must prove that those facts exist, Lordship. Para number 10, Lordship, pleading is not evidence, far less proof. Issues are raised on the basis of pleadings, the defendant appellant having not admitted or acknowledged the fiduciary relationship between the parties. Indisputably, the relationship between the parties itself would be an issue. The suit will fail if both the parties do not adduce evidence in view of section 102 of the Evidence Act. Thus, ordinarily, the burden of proof would be on the party who asserts the affirmative of the issue, and it rests after evidence is gone into, upon the party against whom, at the time of question arises, judgment would be given if no further evidence were to be adduced by the other side, Lordship. Para number 19, Lordship, the another aspect of the matter which should be borne in mind, the
Okay, Mr.
distinction,
Das.
yes, this is para number 19, Lordship, of my judgment which I have relied, Lordship. Now, Lordship, another aspect, Lordship, I would like to raise, that during the pendency, Lordship, I prefer the petition under Order 41, Rule 27 CPC in the instant proceeding. And Lordship, before passing of the judgment, Lordship, the said petition which I had filed, if Lordship comes to, Annexure 19 is the, sorry, Lordship, Annexure 20, Lordship, the copy of the order dated 6/2/2021, at page 125, Lordship, is the order yes, Lordship. Lordship, now in terms of the Act, Lordship, now section 8 of the Public Premises Act, Lordship, gives the estate officer to exercise powers vested under the Code of Civil Procedure, Lordship. Now, Lordship, in terms of the section 8 of the powers of the estate officer, if Lordship comes to the provision of 8C, Lordship, under 8C, under 8C, Lordship, if Lordship comes, any other matters which may be prescribed. Now, Lordship, in order to prove that the appellant is very well residing under a bona fide Miadipatta land, Lordship, I prefer the petition under Order 41, Rule 27, so that I may be allowed to adduce additional evidence in that said aspect. And Lordship, after hearing both the sides, Lordship, the said order was passed. If Lordship comes to page number 126, Lordship.
No, this is not the order challenge before this.
Yes,
court.
not challenge, but Lordship, it happens to be a pertinent aspect because Lordship,
Maybe
so as to prove.
will not examine this order because it is not the subject matter of challenge in this revision petition.
Yes, Lordship, since the subject matter of challenge is the judgment, Lordship, the petition was heard at the time of passing the judgment, Lordship. It was decided at the time of hearing the appeal, Lordship, and accordingly it was passed. And Lordship, this aspect I have raised because if I would be allowed to lead evidence, Lordship, then very well, Lordship, the question regarding the identity or any discrepancy in the boundaries, sale deed boundaries, Lordship, would have been established, Lordship, if they would have a case, Lordship, in such situation, Lordship. That is one aspect which I am raising, amongst others, Lordship. And Lordship, in paragraph number 8, 9, and 10, Lordship, the opinion was made by the Learned Appellate Court, Lordship. And as such, my petition was dismissed, Lordship. Now, Lordship, here, now the respondent's reliance on paragraph number 3 of the petitioner's pleadings are also misplaced, Lordship. That is one aspect which I have earlier raised, Lordship. Because the descriptive of location, not boundaries, not specific clear admission of sale deed boundaries was imputed in the same. narrative description without cogent proof cannot amount to boundary overlap, Lordship. The appellate court travel beyond records by introducing new factual conclusion without tenable and conclusive proof, absence of evidence, which constitutes jurisdictional error, Lordship. This is one of my grounds, Lordship. And for that, I would like to rely on a judgment, Lordship, of our Honorable High Court, Lordship, 2015-5 GLR 731, Lordship. Lordship, here in paragraph number 22 and 23, Lordship, the ratio of the decision, Lordship, has been laid down, Lordship. In paragraph number 22, in case of Muslim Mondal and others versus Union of India and others reported in 2010 to GLT, one of this court, while interpreting while referring to the work of Phipson's, has observed as follows. We have already pointed out that according to Phipson on evidence, which Mr. Dutta relies, the phrase burden of proof carries three meanings, namely the persuasive burden, the burden of proof as the matter of law, and the pleading of burden of establishing a case, whether by preponderance of evidence or beyond the reasonable doubt. The evidential burden, the burden of proof in sense of adducing evidence. Number three, the burden of establishing the admissibility of the evidence.
This is same judgment like the O'Neill Risse. Burden of proof.
Earlier, which I have relied. Lordship, but here 23 is Lordship.
Okay, we'll say.
Yes, 23.
Any other point?
Yes, Lordship, I have, Lordship. Now, Lordship, the most important and pertinent point, Lordship, is that all the lands of Mas Jalukbari, where the petitioner is residing, Lordship, falls within exclusive jurisdiction and control of the state revenue authorities, Lordship, and not under the domain of the railway authorities. Now, unless an authenticated document issued by the state revenue authorities establish an overlap between the sale deed boundaries and the notified railway land or under schedule, no presumption can legally arise, Lordship. This is one of my ground which I am taking, Lordship. On the contrary, Lordship, the petitioner is possessing strictly as per his sale deed. Now, well recognized, the state authorities have well recognized his title, Lordship, and therefore the question of boundary overlap cannot be conclusively established if Lordship, for the moment, comes to annexure Annexure 9, Lordship. Lordship, Annexure 9, page number 59, Lordship. I have also previously pointed out this very annexure, Lordship. This was a reference to the joint verification of identification and demarcation of plot of land, Lordship.
Page number?
Page number 59, Lordship, at Annexure number 9, Lordship. Page number 59 and annexure number 9, communication number GC 27 2014, Lordship. Now, Lordship, if Lordship comes at the bottom part, at number 5, Sri Ashwini Besbora, I am the petitioner here. Now, the state authorities have subbed me a notice, Lordship, because I am a well-recognized patadar. Apart from that also, Lordship, Principal Cambridge Public School, Lordship. It is a CBSE affiliated school.
We are not concerned with that.
Yes, yes, Lordship. I am confined to
So any
the
other
petitioner, Lordship. And Lordship, lastly, Lordship, procedural impropriety, Lordship. As the matter was sub judice before the Honorable High Court, Lordship, the state officer passed the impine order of eviction, Lordship. By subsequently amending the schedule at the first instant, they served the notice wherein the land.
That writ petition has been dismissed by this court.
Yes, Lordship, it was an observation.
How this impropriety will help you?
Yes, Lordship, on that aspect, Lordship, while the first writ petition was pending, Lordship, since there was a mistake in the schedule by the respondent railways, Lordship, I challenged before this honorable court, and accordingly a status quo order was passed. Now, subsequently, while the status quo order was passed, Lordship, the schedule was being amended, Lordship, and subsequently a date was fixed and the order of eviction was passed, Lordship. And Lordship, so far as Lordship maps cannot prove encroachment, Lordship, because they have totally relied upon internal maps on the basis of which they have just put the name, but there is no conclusive. Over and above, I'm submitting before your Lordship.
Okay. Okay, after
Yes,
at 2 p.m. we will heard.
yes.
There I have a case before you. Today, I retired it on Lordship.
Pardon?
That day, Lordship, I have test my case, Lordship.
Ah,
That's why that part.
today you have nothing to submit.
I will just two key points that I.
Okay,
Lordship.
okay.
Lordship, regarding schedule of the land, Lordship, it is already I have submitted, Lordship. So my lord may kindly come to Lordship. Paragraph 3 of page 91 of the plain, Lordship. This already Lordship has gone through it. Then
Paragraph
my lord may
number
kind-
3.
Paragraph 3 of plain, Lordship. Page 91, Lordship. That part I am not retired, Lordship. The boundary part they have described that.
Page 91.
Page 90 and 91, Lordship. Paragraph 3,
Mm.
Lordship. I am not retired. It is already I have explained before, Lordship.
Yes.
And several times my lord have gone through it. Then my lord may kindly come to page 109, Lordship. Paragraph 94, Lordship.
109.
109, Lordship.
Yes.
Last time, Honorable Lordship, court line, Lordship.
Mm.
They have time and again, same thing was they retired, Lordship.
Mm.
Available, Lordship, side of the appellant, my lord got it.
Which part you were reading?
Lordship, paragraph, page 94, Lordship, first paragraph, the continuation of Lordship, paragraph 6. It starts from page 93, Lordship.
Mm.
That's the relevant point I indicated.
Mm.
Page 93, Lordship,
Mm.
is the paragraph 6, and my lord may kindly come to next page 94, Lordship.
Mm.
I starts from fifth line, Lordship.
Mm.
The side of the appellant Vyadipatra lane, on the eastern side of the appellant lands, the old and existing railway line is situated, and such eastern side is the left side of the said old railway line. This is the admitted case. Time and again, they have reiterated, Lordship. Not only Lordship, paragraph 3, Lordship, paragraph 6 also. Then my lord may kindly come
No,
to
no,
Lordship.
no. Page number 94. Line number.
Line number, Lordship, 1, 2, 3, 4, 5, 6. On 6th line, my lord may kindly correspond to 6th line, Lordship.
6 line.
6th line, Lordship. It starts from Lordship, side of the appellant's Vyadipatra lane,
Okay.
Lordship.
The side of the appellant Mary Patta line.
On the eastern side of the appellant's land, the whole existing railway line is situated, Lordship.
Mm.
Then my lord may kindly come to page 109, Lordship.
Mm.
Page 109, Lordship, paragraph 90, my lord got it.
99.
109, Lordship.
109.
Paragraph 19, Lordship.
Mm. Yes.
I starts from 7th line, Lordship.
Mm.
The appellant fairly admits that on the eastern side of his land existing board gauge line belonging to the railway is there, but there is a clear boundary mark of the independent land, Lordship. Time and again in his pleading says that, Lordship, eastern side is the railway line.
Mm.
It is the admitted fact, Lordship, there is no dispute, Lordship. The land which was purchased by the petitioner is a defined land, and occupied land is a totally defined land, Lordship. It is within the 39 meters of the railway boundary, Lordship.
Within 39?
39 meters, Lordship.
Okay.
Even, Lordship, I have placed that map also, Lordship.
Mm.
Who is that particular map was considered in paragraph 34 of the judgment, Lordship.
Mm.
Before that, Lordship, regarding pleading part, just I point out one judgment, Lordship.
Mm.
This was a recent judgment, 2025, SCC online, SC 2064, Lordship.
Mm.
My lord, may I kindly come to paragraph 18, Lordship. Paragraph 8. Lordship, kindly look at it, I just mark it. Lordship.
Yes.
Paragraph 18 also, in this regard, we place our reliance on the well-entrenched principles of law that no relief can be granted on a case that not founded in the pleadings, Lordship. This court cannot entertain an entirely new case at the appellate stage at behest of the either party and is strictly confined adjudicate to the issues arising from the suit as framed by the pleadings of the parties, Lordship. For the pleading part, I am relying that particular person, Lordship. They are pleading, Lordship, time and again in 3 to 4 paragraphs. They have stated it, and not a single paragraph in the plain, Lordship. They have described the schedule land which was purchased by the original sale deed, Lordship. Not a single paragraph is there, Lordship. Only they have stated that part, Lordship. And also that was considered by the Honorable Tribunal, Lordship. Tribunal judgment, my lord says already gone through it. I am not repeat it, Lordship.
You are referring to paragraph number of that judgment?
Lordship.
You have referred to one paragraph of the judgment?
Last place judgment, Lordship. Paragraph 18, Lordship.
No, impugned judgment.
Impugned judgment, Lordship. Paragraph, it's just I indicate, Lordship, regarding railway 39 feet, Lordship. It is paragraph 34, Lordship.
34.
Paragraph 34, Lordship. The plan sheet which was, Lordship, mentioned here, that plan sheet is I have, Lordship. That's why I the right question. This is the plan sheet which was relied by the Honorable Tribunal, Lordship. Honorable the court, Lordship.
Appellate court.
Trial court, Lordship.
Appellate court.
Appellate court. This is the plan sheet, Lordship. Sheet number 82. There is a clear mark is there, Lordship, regarding 39 feet part is there, Lordship. That document was considered, Lordship.
Okay.
That document was considered, Lordship. And regarding enforcement part of the Lordship, that was considered 39 feet is there, Lordship. It will. Lordship, that document very clear. This document also part of the Lordship. The red mark two is the petitioner's land, Lordship. Two petitioners have occupied the railway track, Lordship, within 39 meters, Lordship.
Okay.
Two is within the 25 feet, Lordship. And that document was also considered, Lordship.
No, these documents are exhibited.
That was exhibited, Lordship. That is there. That was exhibited in the paragraph 34 also mentioned it, Lordship.
Paragraph 30.
Paragraph 34, plaintiff number 30, Lordship. This is the plaintiff number 82, Lordship. That's why that's indication I have to bring it, Lordship.
Okay.
And also regarding the 227 jurisdiction, my lord said already passed several orders, although I have just placed, Lordship, one judgment, Lordship, for reliance, Lordship. I am not retiring, just I make the paragraph, Lordship, paragraph 15, 16, and 42, Lordship. 2010 9 SCC 385. 2010 385.
15, 16,
16, and 42, Lordship. 15 is internal page 390, Lordship.
Okay.
Lordship, one thing I have to, this is concluding my judgment, Lordship. Concluding my argument, Lordship. It's a, Lordship, project of the national importance, Lordship. It's an infrastructure project, Lordship. So I am relying, Lordship, section
Specific
Specific
relief act.
relief act lordship, section
Okay, all right.
41, that part lordship, 41H say lordship. That part I am relying only. Which I, only because of that portion lordship, we are unable to proceed lordship. Even the Kreke Henrik always also lordship, they have behind, they have back lordship. And one mandir was also there lordship, that was also lordship, removed lordship. Then the local public themselves, they have removed lordship. And only that, this is my humble submission lordship. Lordship.
Lordship, if Lordship gives me an opportunity to counter the submission.
Yes.
Lordship. Now, Lordship, they have relied on the departmental map, white plan number 82, sheet number 82, where they have marked me as an encroacher, Lordship. Now, my issue is that, which I would like to raise, whether maps can determine encroachment. Because they have shown a map, they have relied a map. Apart from that, Lordship, if Lordship calls for the records of the estate officer, Lordship, apart from plan number 82, there are no other records. In that respect also, since there is a railway line to be formed, Lordship.
No,
already in
you
my-
tell me whether these documents are exhibited
We have
before the appellate court?
No, Lordship, because Lordship, the appellate court, on the basis of the records of the estate officer, Lordship, has passed the judgment. And Lordship, over and above, Lordship, the point which was determined by the Learned Appellate Court was regarding whether the impugned findings are sustainable of the are sustainable or not of the estate officer. But Lordship, regarding the point whether the land is a public premises or not, that was not being adjudicated by the appellate court. Nowhere in the judgment. This is one for the purpose of submissions only. I am placing Lordship, and whether the land falls within the meaning of public premises or not. On and again, I submitted.
No, whether such a pleading was there in your memo of appeal.
Lordship, I placed my arguments, written arguments, Lordship, where I have placed that my land
It
doesn't
was not
fall.
in your pleading.
Yes. But in the memo of appeal, Lordship, sorry, in the written arguments, I have placed, Lordship. And for that reasons only, Lordship, I prefer the petition under order 4127 CPC, Lordship, for the purpose of issuing additional evidence, Lordship. And Lordship would also consider my RTI replies
You
also.
say, since the land is a public premises, the state officer has passed the order.
Yes.
And that order you have challenged before the appellate court. So whether any further determination is necessary?
Yes, Lordship, because the findings of the estate officer.
Admittedly, the proceeding is a summary proceeding.
Yes. Now, summary proceeding, Lordship, during the course of proceeding before the estate officer, Lordship, I placed my documents over which I rely that I am the bona fide owner of the land, Lordship. Now, that were not examined, Lordship, on the basis of the plan number 82, Lordship, without correlating with the state revenue authorities, the impugned findings were made.
That 39 meter from the railway line, that was identified by the railway authority with the help of revenue authority.
39 meter within the middle point of the railway line also.
Yes.
Middle point of the railway line also.
Yes.
Now, they proposes to evict me, Lordship, from the land which I am possessing. Now, the question is whether I fall within the 39 meter or not, whether I am within that or not, Lordship. Because I am possessing my land, Lordship. Now, they said the whole parcel of land is a public premises, Lordship. There are no measurements or no correlations being examined. Technical verification is required, Lordship. For that purpose only, I am submitting, Lordship.
Okay, we'll see.
Yes. Lordship, lastly, one judgment, Lordship. Last judgment. 1977, 1 SSC 133, Lordship. I would not reiterate, Lordship, but I rely on para number 16, 17, 18, 19, 21, 22, and 23 of the judgment.
Okay. Heard Mr. Das, Learned Counsel for the petitioner, and Mr. Gogo, Learned CGC for the respondent. Argument concluded, order is that. Interim order will continue till final order is passed.
Much obliged.
No, caveat will be hard, caveat is. Unna lage, na lage, unna. To finally dispose of portfolio.
Item 15.
Yeah, please, your lordship, kindly pass over the matter for some time.
Sometime means,
He is in
about to
leg,
wind up.
the youngest counsel is in legs in court
Okay.
number 18.
Okay.
He will appear.
Okay,
Must oblige, your lordship.
yes.
Item 16.
Well, at a concurrent finding of the both trial court and first appellate court, it's a landlord tenancy dispute,
Okay.
and I am for the tenant.
What is the ground?
The ground, before I take your lordship to the ground, I like to take your lordship to the prayer made in the plain, page 22 of this CRP.
No,
The
pair
plain-
is in page number 15.
22,
Page number?
22.
No, no.
I don't know what happened actually. This brief was handed over from the previous council.
Mm.
And in fact, some pages are also missing in my brief. Little bit difficulty. I'd
No,
like to,
here you see the pair start from paragraph number 14, page number 15.
no, that prayer in the plaint,
Okay,
prayer in the plaint.
okay.
Plaint starts from page 19. I'm sorry, my lord. I thought there are some missing pages are also there.
Yes, 19.
19, the plaint starts. And page 22 is the prayer made in the suit. A is a decree of ejectment of the defendant number 1 and 2 by removing their man materials from the tenanted premises, more fully described in Schedule B to the plaint.
Mm.
Decree of cost of the suit, decree any relief or reliefs which the plaintiff is entitled to under the law and equity. So your lordship is saying there is only prayer for eviction.
Mm.
There is no prayer for recovery of area rent. And if there is no prayer for area rent, your lordship will held that the tenant is not in defaulter of the land. But
No, no, you see the number C.
yes, any relief.
Or reliefs to which the plaintiff is deemed entitled to under the law and equity.
Yes, but that area rent has to be specifically, because if your lordship sees the paragraph 5, the previous page, page 21.
Mm.
In 2012, the plaintiff says that the plaintiff begs to submit that as the defendants have miserably failed to pay the monthly house rent from July 2012, they have no right to continue as a tenant under the plaintiff besides this so and so, so and so, so and so. But they have not said that they want the money, area rent, because
you see, it is an equitable relief. The trial court has granted that relief.
Yes.
Granted.
No, the trial court has only granted the
Ejectment.
issue. Yes,
Okay.
but the issue was framed that whether the tenant defendant is in defaulted in that is why the ejectment decree was passed.
Mm.
And moreover, in this plaint, the plaintiff has categorically stated that she wanted the premises for bona fide reasons. And to that effect, no issue was framed by the learned trial court. whether the suit premises were required bona fide for bona fide requirement. to the
Whether trial court has recorded any finding on
No.
that one? No.
That is the issue.
No, forget about that issue.
Yes.
Are
Another-
you not liable to be evicted on the first ground, on the ground of this default?
Default, only on that ground that the landed trial court has
Pass
also
the ejectment order.
ejectment order. I have annexed some of the documents.
Mm,
Kindly see page 23.
mm,
That is the schedule.
mm.
The schedule B, the plaintiff wanted to evict me from the schedule B premises.
Mm.
And the description of the schedule B premises has not been given
Mm.
in the plain. I left it for the
No,
execution.
yeah, it is mentioned two Assam type houses
To Assam,
along with a bakery, which
yes,
was standing upon the schedule A land and covered by holding number 43 and ward number 28.
yes, correct. Yes. Now your lordship will see. For the time being, I am skipping the written statement.
Mm.
The evidence of the defendant number one. Only PW one has deposed
No,
before.
Mr. Dhor, you see, this is a revision petition.
Yes,
In the revision petition, we will only see the legality, property, and correctness of the impugned judgment and order.
correct,
We will not appreciate the evidence here.
correct. But both the learned trial court as well as the first appellate court has not appreciated the evidence of the sole evidence of the PW1. Because she has categorically deposed before the court. Your lordship will find page 35. Kindly see and this is the only basis for granting the relief. Page 35 is the cross examination. It's just 2 page. I just read. I have filed this suit against Iti Ghosh and Narayan Ghosh for eviction of the defendants. The tenanted premises is 1 katha. I have filed this suit for eviction from the 1 katha of land. I cannot say the four-side boundary of the tenanted premises. On being the copy of plaint, the PW1 has denied to identify the same. I do not know the contents of my plaint as I don't know English. On being shown the evidence on affidavit of PW1, she has denied to identify the same. I also do not know the contents of my evidence on affidavit being written in English. On being shown the copies of exhibits 1 to 7, PW has denied to identify the same and also do not know the content of the same being written in English. I have not filed any tenancy agreement of the defendant in this suit. I also don't know specifically the contents of exhibit 5. I also do not know who has written the exhibit 5. I do not know whether any WS has been filed by the defendants or not. The proceedings of the suit and documentations of the suit are looked after by my husband and my son, Sanjay Raut. Hence, I do not know about the same. I have claimed the rent since month of June 2012. So here is a contradictory statement. I have claimed the rent since the month of June 2012, but I cannot remember the date. What is the say of the defendants in this suit against my allegation of default and prayer for realization of area rent? I do not know. My husband and my son know the same. In this suit, I am the only witness for plaintiff, and I do not have any other witnesses to be led in this case on my behalf. Tent house business is run by me. I have not filed any documents to show the tent house so and so. I have obtained building permission in Form GMC in the year 2009. Kindly see the conduct of the plaintiff. I do not know the validity of the permission and whether the permission is in force on that on date or not. I do not know. After 2009, I have not filed any application for building permission. I do not know the day, DAG number, patta number, revenue village of my purchased land. The tenanted premises of this suit consist of 4 rooms. I cannot say whether the 4 rooms are shown in the schedule of my plaint or not. I know that the defendants have been paying the monthly rents in court since the month of June 2012 in my favor. Kindly mark this word. These are not been considered at all by the trial court and the first appellate court. I know the defendants have been paying the monthly rents in court since the month of June 2012 in my favor. It is the fact that the true facts and in the facts and circumstances are not known to me, and those are known to my husband and son. So during cross-examination, the plaintiff herself says that she is aware that rent has been deposited in court since 2012. And
whether the petitioners laid any evidence before the court?
no, because after her cross-examination, she could not prove anything. It's the case of the plaintiff. The burden of under section 101, your lordship is aware, just I was hearing the previous argument. A judgment was cited by the counsel. 101 lies on the plaintiff. She has to prove. And the requirement, bona fide requirement, she asked to vacate the tenants to in the 2009 because in 2009 she obtained a
So, you have not adduced any evidence?
No.
Hmm.
And in 2009 she obtained a building permission that was exhibited, but since 2009 till 2012 nothing has been done. And moreover, in cross-examination, she has admitted that she has not renewed that construction permission. So where is the bona fide requirement of the plaintiff respondent? Now, I'll take your lordship to the issue framed by the trial court, page 41. Relevant issue is issue number 4.
Where is the examination in chief?
Chief is my lord, page 32.
Page 32.
Yes.
So, Mr. Dhor, you see, Since the month of June 2012,
Yes,
you have been paying rent in the court.
July.
Hmm. You paid rent up to June 2012,
Yes,
and you are paying rent since July 2012 in the court.
yes. But
Why you are depositing the rent in the court instead of tendering it to the
yes, that I have,
to the plaintiff?
yes, that I have stated in my uh, written statement.
Hmm.
There are other tenants also.
Written
Paragraph,
statement is at page number
page number 25.
25. Okay, in which paragraph you have stated?
Yes, paragraph 16, page 27.
Hmm.
It's a long paragraph.
Hmm.
May I just read out?
Hmm.
It is pertinent to mention here that in respect of tenancy between defendant number 2 and plaintiff, their tenancy is not disputed.
Hmm.
There is no written agreement, and also there is no fixed due date for payment of monthly rents. As per convenience of the plaintiff, she used to collect the rents monthly, bi-monthly, and sometimes for months together right from atonement. The plaintiff had received a monthly rent from defendant number 2, and all the receipts signed by the plaintiff used to be handed over to the defendant number 2 by her husband regularly. Thereafter, the plaintiff had received the monthly rents for the tenanted premises from defendant number 2 for the months of July, August, September, October, November 2012. Altogether, in the second week of December 2012, being 3,500 through her husband, Sri Narayan Rao, who appears to be criminal nature and character, and also having past criminal antecedent, and even he had to remain behind the bar for so many times for his criminal acts. At the time of receipt of this rents for the month of July, August, September, October, November 2012, altogether in the second week of December 2012, being 2005, the malafide husband of the plaintiff had shown his inability to provide
Okay,
permanent receipt.
okay. And you have not laid any evidence before the court?
No,
No. So this pleading remains not been proved. The content averment made in the pleadings remain unproved.
unproved.
Then how this will help you? So before tendering rent in the court, you
Yes.
have to tender it first to the landlord.
My lord,
If the landlord refuse to accept it, only then you are entitled to
yes,
deposit the
paragraph 17, my lord. Paragraph 17 of my
in your
written,
paragraph number 7.
17 of written statement.
But this written statement has no value. You have not entered into the witness box.
That I can understand, lordship, but
Yeah.
at the same time, if the plaintiff fails to prove her own case, whether the defendant
No, that averment of the plaintiff is there in the plaint and also in her examination in chief. It is a fact that she could not state some of the facts in her cross-examination.
Correct.
But can the averment made in the pleading and in her examination in chief can be wiped out?
No, my lord. Then also, then again, the cross-examination will come. Her cross-examination is totally contradictory to whatever she has stated in plaint as well as in her evidence. Because your lordship has seen, she denied to identify the plaint. She denied to identify her chief. She even doesn't know the boundary of the suit land. And she knows that the defendant has been deposited the land in the court. So if the deponent, if the plaintiff herself disowns her own plaint, disowns her own evidence, whether the trial court as well as the first appellate court was correct in appreciating her evidence,
No, you see, in the later part of our cross-examination, she stated that the tenanted premises of the suit consist of 4 rooms.
Yes,
There is not even a single suggestion that the suit premises is not belonging to her. She is not owner of the same.
no, that is not in dispute, but there are some other tenants also that is not been pleaded case, her pleaded case. We have stated that there are other tenants also. She has not made parties.
Since you have not entered into the witness
That cannot
box
be,
to
that cannot
fix
be
the
looked into.
cross-examination.
That cannot be
In view
looked
of the
into.
decision of Supreme Court in the case of that Vidyadhar Manikral.
Correct. Correct, Pani.
So your written statement has no value.
No value.
You have no case. There is nothing on the record to show that before depositing the rent in the court, you have tendered it to the landlord, and the landlord has refused to accept the same.
Correct, correct. That is correct, Lordship. But my only question what I posed to me, whether in such a case where the plaintiff herself questions the plaintiff as well as her evidence, whether the court can take cognizance of those plaint and evidences led by her, whether she has be able to shift her burden to the upon the defendant.
No. This burden is upon you that you have tendered the rent to the landlord.
No, that I am not disputing. That is not in dispute. Her case is that she required the tenanted premises on bona fide ground.
No, forget about that ground.
Yes.
Bona fide requirement. Okay, it is not proved. But why you should not be evicted for defaulter, for being defaulter?
That part she has also not been able to prove. Although it was the duty casted upon the defendant to take on record all these NJ cases. Because all the numbers have been stated in paragraph 17 of the written statement, and probably the conducting counsel have advised him not to adduce any evidence because of her cross-examination as well as chief. But still the requirement of bona fide on the ground of bona fide requirement, that has not been proved. And the defaulter, issue of defaulter has also not been proved. Because she herself says that the defendant has deposited the rent before the court. She knows it.
Okay. Yes, what is your case?
Respectfully, I have nothing to make, but your lordships have understood the facts of the case. Section 5(4)(e) of the Assam Urban Areas Rent Control in India. Your lordship knows it, your lordships. Assam Urban Areas Rent Control Act.
Section 5(4)(e).
Where the tenant has not paid the rent lawfully due from him in respect of the house within the 14 nights of its falling due. That is one of the grounds, Your Honor. They have held to prove that they have paid the rent to me. They are shifting their burden on me. That I have to prove their case. It is their duty. I have proved my case. I have also exhibited the document. I have also stated that they have paid the rent to me till June 2012. Thereafter, from July 2012, they did not pay the rent. Till today, Your Lordship, neither they paid the rent to me, not deposit the rent in court. They even did not call for the records of the other cases. Nothing on the record. Even they have not exhibited the trans, rent deposit trans. Nothing is there. Rather, they have stated, as you have seen, that in their detailed statement, they have stated that no, they have also paid the rent for the month of July, August, September, October, and November. It is their case. Now they are saying that since the plaintiff has stated that they deposit the rent for the month of June, so they are telling that no, they are depositing the rent in court. That is not there because my case is this. Perhaps she was the housewife, and she, in the evidence on affidavit, she has clearly stated that up to the month of June 2012, she received the rent. Perhaps in writing, in saying, she wanted to say that only up to June 2012. But somehow that was written. But question is this: burden on them to prove. No suggestion was even given to the PW1 that we are making a false statement. We have paid the rent to you up to the month of November, so and so. Thereafter, we also offered the rent to you, but he refused. Thereafter, we are depositing the rent in court. Nothing, no suggestion, nothing was. So now their burden to come before the court in the witness box and prove the statement made in the written statement by exhibiting the document. Nothing. That's why, Your Lordship, both the trial court as well as the appellate court found them defaulter. And accordingly, passed the decree for the rejectment. Now, Your Lordship, he is making a submission that there is no discussion regarding the bona fide requirement. But, Your Lordship, that I am the plaintiff, I have to raise that issue. It is for their benefit that the decree was not passed on the ground of bona fide requirement. Decree was passed on the defaulter. If I am agreed that why the material decree was not passed on the bona fide requirement, I can raise this material question before this honorable court that the order passed by the court is not in accordance with law. How they can? Only one issue because there are 6 issues. All issue is material decided in power, including issue number 5, that whether he is a defaulter or not. I found that he is a defaulter. So what remains, my lord? And since July 2012, my lord, without paying a single person of 2026 running, my lord, they have not paid even single. And they have admitted the tenancy. They have also admitted that yes, I am the landlord. Schedule description of the their tenure is given in the schedule. Everything is there, my lord. So as per the section 5 of the Assam Resident Control Act, they have to pay the rent either to me or to the deposit all my refusal in the court. Refusal tendering are not there. Your Lordship knows there are so many children even Your Lordship this court is also there, my lord. Decided by Honorable Justice J. Sarma in the that it was that was decided by Honorable Justice J. Sarma, 1997 to GLT. Duties of tenant. A tenant is under liability to payment of rent or through such liability subsists even when the proceeding may be pending before the higher court. Nothing on the record, my lord. They have not deposited note of her. And there must be evidence that there was refusal by the landlord. Tenant must tender offer due rent within the fortnight of responding due, which is the precondition to the deposit rent in court. Section 5.
Okay, not necessary to argue the matter further. Okay, all right.
I just, and this is not in context with this appeal, although it was not been executed, exhibited, all the originals are with the defendant, but it
Maybe,
is of
but
no use right now.
those documents will help you.
No,
At
that is why I'm just asking, I just want to rely on this judgment on the
Okay.
plea of bona fide requirement.
Mr. Edhor, learned counsel for the petitioner, and Mr. Sunsetive for the respondent. Argument concluded, order is out.
Paragraph 18 of this judgment.
18.
18. Okay. Obliged, sir.
Pending item 15.
Okay, this is a transfer petition praying for transfer of a guardianship case, Your Lordship, from the court of family, from the court of principal judge, family court Kachar to the court of district judge Bongaigaon, Your Lordship. This petition has been filed by the mother, and the guardianship case was filed by the father, Your Lordship. Apart from the grounds for transfer that there is inconvenience on the part of the mother to contest it in Kachar, Your Lordship, because they are separated since 2016, and the child is staying with the mother at Bongaigaon, admitted in a school at Bongaigaon from the year 2016.
Instituted. FC Civil GA case number 22 of 2023, seeking custody of the minor. Minor son.
Daughter.
Minor daughter. Minor daughter. Mr. Mukherjee, learned counsel for the petitioner, further submits that the petitioner is residing at her parental abode at Bongaigaon. Parental abode, Bongaigaon, and she has a daughter, and presently she is living with her, and she has also instituted one divorce proceeding, being title suit number
Title suit D 21/2021.
21/2020, which is pending before the Court of Learned, District Judge Bongaigaon, and further referring to subsection 1 to section 9 of the Guardians and Ward Act 1890, Mr. Mukherjee submits that the Court of District Judge Bongaigaon has the jurisdiction to entertain the application as the daughter of the petitioner is residing with her at Bongaigaon. And as such, and further, he submits that with the minor girl, it becomes impossible on her part to contest the aforementioned proceeding at Silsor, and under such circumstances, he has contended to allow this application by transferring the FC Civil GA case number 22 of 2023 from the Court of Principal Judge, pending before the Principal Judge, Family Court Kasar Silsor, to the Court of District Judge Bongaigaon. Further, having heard the submission of Mr. Mukherjee, learned counsel for the petitioner, this court has carefully gone for the petition and the documents placed on record, and also perused the relevant provision of law. Subsection 1 to section 9 of the Guardian and Wards Act 1890 provides that if the application is with respect to the guardianship of the person of the minor, it shall be made to the district court having jurisdiction in the place where the minor ordinarily resides. In the instant case, the petitioner, the minor daughter is living with the petitioner, who is residing in her parental abode at Bongaigaon. going on. And as such, the Court of Learned Districts is going on has the jurisdiction to decide the application seeking guardianship of the minor. Accordingly, taking note of the submission of Mr. Mukherjee Learned Counsel for the petitioner and also considering the relevant provision of law, that is section 9(1) of the Guardian and Wards Act 1890, this court is inclined to allow this application. Accordingly, it is provided that GA case number 21 of 2023 pending before the court of
22, Lordship. It will be 22 of 2023. That's correct.
what is there in the petition?
22, Your Lordship. 22.
Case number
GA 22 of 2023. In synopsis, it may be 21, Your Lordship. But because
Synopsis.
initially we filed 21, the notice we received of 21. Thereafter,
you have filed amended cost item?
yes, amended cost title was filed.
Okay, 22 of 2023. Stands transferred from the Court of Learned Principal Judge Family Court, Kasar Silsor to the Court of Learned District Judge Boyo. In terms of this transfer petition is disposal.
Seventeen.
May it please also. My lord, we have filed this revision petition, my lord, challenging, my lord, an order dated 27/5/2025, whereby, my lord, the prayer for amendment was allowed. The amendment prayer was filed by the respondent, sole respondent, my lord. My lord, the facts of the case are like this, my lord. If your lordship will kindly see page number 13. 13 is the probate petition. This probate petition was filed by the sole respondent before the court of the district and session judge Kamrup Metro. The case is like this, that my lord, one Nokul Chandra Borua, he died on 29/12/2017. Before his death, he allegedly executed a will in favor of the sole respondent, who happened to be the nephew. And that will was registered on 22/11/2017. By this will, the Schedule A and Schedule B property were given in favor of the sole respondent. Now, thereafter, my lord, Ranjit Borua, that is the respondent, he preferred this probate case against the wife. That lordship will kindly see page number 14. ODT Soitali Borua,
No,
Raktim
you tell
Ranjan,
me at what is this? The probate case was pending.
cross of PWs.
PW.
Cross of PWs. Now, if I make it short, my lord, what happened was that they, in their probate petition, they simply said that the will was executed by Nokul Borua in his favor. Now, how it was executed, whether by affixing his thumb or by putting his signature, that was not mentioned. Thereafter, my lord, several dates were passed at the time, at the stage of cross of PWs, and their cross was even closed. Lordship will kindly see page number 31. Page number 31. Cross examination was closed because on 6 dates they did not adduce any evidence. But suddenly, my lord, all of a sudden, they filed a petition under Order 6 Rule 17, praying for amendment of the probate petition. this time saying that they want to amend the petition for incorporating that part as to how the will was executed, whether by putting his thumb impression or by putting his signature. Because my lord, in the written statement which we filed, we took a specific plea that my lord, this Nokul Chandra Boru was a practicing lawyer and he could never have put his thumb impression. Because he is a literate person, he will definitely put a signature, no thumb impression. So that part was not there in their initial probate petition. Now, after that, my lord, they, my lord, filed this petition for incorporating, my lord, that part. Lordship will kindly see the Order 6 Rule 17 petition at page number 32. It starts from page number 32 and the relevant para is at page number 34. This is the relevant para which they want to incorporate. That the writer of the will, as per the instruction and saying of the testator, prepared the will and presented before him, and the testator, after reading the will, having found the same to have been written as per his saying stated to be the writer, and with neurological disorders, he had become completely unable to write his signature and be asked the writer to take his thumb impression, that is LTI in the will in all the pages of the will on 7/11/2017 in presence of the attesting witnesses. That the writer Mukul Deka, after taking the LTA of the testator Nokul Borua, gave endorsements like this taken by Mukul Chandra
Okay,
Deka.
Mr. Das, you
Yes.
tell me, when they have filed, when the suit was filed, that this probate application was filed,
It was filed, my lord, on 2018, April 2018. At page number 22.
18 April,
April
page number
22, affidavit.
page 22. And when the application for, no, when the WS was filed,
WS was filed, my lord, on 11/11/2021. Because initially, my lord, they did not make us a party.
okay.
Because the petitioner is the second wife of the
Okay, when,
so after implement, we filed a written statement.
okay, when the examination in chief was closed, or no, cross-examination was closed,
On, my lord, 9/4 to 23/2/2024
23,
to February 23 February 2024.
2024. Evidence closed.
Evidence closed.
And when they filed the application,
21 June 2024.
whether they have offered any explanation for which they could not file the
Yes, that is the main
application
thing.
beforehand.
That is the main case contention, my lord. The thing is that as per the proviso of Order 6 Rule 17, the due diligence part will have to be satisfied. Now the due diligence is of the party, not of the lawyer. Now this portion, it cannot be said that it was not within the knowledge of the respondent, Ranjit Borua. Whether the original testator he affixed his thumb impression or signature, it was definitely within the knowledge. If, my lord, if it was a document or some fact which was not within his knowledge, subsequently it came to his knowledge, then that part will come. But if something was well within his knowledge, but because of some negligence on his part, then he cannot take the relief of Order 6 Rule 17. That's what has happened in this case, my lord. The lordship will kindly see the explanation which they have provided in the petition at page number 33. Para number 3, fifth line, that the new set of lawyers who have recently been engaged have found mistake as to the omission to state as to how the testator executed the will, whether by writing his signature or somebody at the instance of the testator signed or executed the will by putting his thumb impression. But that was definitely within the knowledge of the Ranjit Borua. It cannot be said that that was not within.
Whether you have raised such a contention before the trial court?
Well, we have categorically denied their in our objection. We have categorically denied their claim, my lord. Both in the written statement as well as, my lord, in the objection which we filed, because it will comes within the bar of Order 6 Rule 17 proviso. If your lordship will see order 6 rule 17,
No, that's all right. There is also decision of the Supreme.
yes, LIC judgment is there.
No, no, not LIC. Another judgment is there
Well-
that due diligence has to be shown,
Yes. And
has to be demonstrated.
yes, due diligence of the party.
Yes.
But here they are taking the plea, the due diligence of the lawyer. Earlier engaged lawyers did not make the necessary plea in their petition. That is their case. It's not that the due diligence, in spite of due diligence, that was not communicated to the lawyer, or in spite of due diligence, that was not known. That was not their case. Their case is that their earlier engaged lawyers did not write these things. So subsequently, after the new lawyers were engaged, they came to know, and then they made this petition under order 6 rule 17. That is their case.
Okay. So how how the trial court has dealt with the issue? In
Trial court, by relying the LIC judgment, has allowed this, imposing a cost of 10,000.
No, no, LIC judgment has not dealt with this due diligence.
Yes.
Whether it has dealt with?
No. Lordship will kindly see page number 53. 13, para number 13. That is the only minor discussion.
Page number?
53.
Yes.
Para number 13. It appears that although the plaintiff petitioner has filed the amendment petition at a belated stage, the proposed amendment is not inconsistent with the pleadings of the plaintiff. Although the deceased testator was an educated person, while executing the will, he put his thumb impression. The reason for the same needs to be judicially scrutinized in order to ascertain the genuineness of or otherwise of the will annexed. Hence, it may be said that the proposed amendment is required for a just decision of the case. However, the plaintiff petitioner ought to have filed the amendment petition beforehand. They prefer to file the amendment petition at the stage of evidence. This has not only delayed the proceeding but also prejudiced the OP defendant. Considering all aspects, the amendment petition is allowed with a cost of rupees 10,000 to be paid to the defendant. The due diligence part has not been discussed.
After arriving at the finding that this has not only delayed the proceeding but also
Prejudiced the
OP
defendant.
defendant.
Yes.
What is the scope for allowing the application?
Yes.
Okay. Yes. What is your stand?
It's not the wife of the testator, Lokul Chandra Borla. My son has submitted that is his son. Is now his son. Is now doing business in the USA. And third is the daughter, or no, second is the daughter. She is the baby. And fourth is also a daughter. So these are the actual legalness. Oditi Burla was the professor of cotton college. She is the married wife of the testator.
No, that's all right. We are not concerned with the factual aspect.
Now,
how do you explain the delay?
that the new settle on earlier lawyer are new advocate, and he does not know how to explain how to give how to write.
No, that change of advocate cannot be the ground.
No, sir. No, my lord. That because due to the fault of the lawyer, the party cannot suffer.
That's all right, but that's not always true.
No, my lord. I am an ordinary person. I do not know the procedure, how the pleading is to be written. So I engage the advocate, but if he cannot properly make involvement in the pleading, then what will be the next step? So subsequently, he rejected from them. And the new set of advocate was engaged, and new set of advocate found that the will was executed by putting thumb impression of Nakul Bora. For what reason? Being a highly educated person, Nakul Bora did not put his signature. These things were not stated because whether execution, whether the will was sign or by giving his signatures or by putting his thumb impression, these things were not explained. And Nokunwara, for what reason? He could not put his signature. He was about 80 years of age when the will was executed. And he was suffering from neurological disorders. That is why he has advised the writer to write the will. And thereafter, he asked the writer in presence of the witnesses to put the thumb impression because he cannot write them. So these things were not pleaded. The evidence is to be preceded by the pleading. When the manner how the will was executed was not heard. So proper execution is to be proved. That is why the new set of lawyers filed an application seeking the amendment of the petition and stating all these things. And secondly, he has also, earlier lawyer was also committed another wrong.
No, you tell me when the new set of lawyers were engaged?
New set of lawyer was engaged after 24, in the year 24. 24.
In the year 2024.
24 in the month of August.
2024. And when the application was filed for amendment?
Yes.
21 June
20
2024.
21 June 2024. But the evidence was closed on 23rd to
24.
24. You see, since 2021, WS was filed on 11/11/2021.
9/4/2024.
Now these things were not objected, but they have objected to that extent that the
But the question is whether changing of counsel and shifting burden to the earlier set of counsel would absolve you in explaining the delay in filing the application.
no, earlier lawyer did not file the amendment petition.
No, whether that can be a justified ground.
New set of lawyers filed the petition under Order 6 Rule 17. Now, my lord, in this case, the opposite party, number 1 to 4, who are the main persons, they have already filed their return statement. The amended plan is filed. And thereafter, the parties were asked to submit their return statement. The opposite party number 1 to 4 have already submitted their written statements against the amended plan. And they have also received the compensation amount. So now the opposite party number 6 is not at all related of the disease. He always is blind. The wife, as a matter of fact, she is not the wife, and she cannot be the wife. I am submitting it to your lordship. One of the objections filed by them with their objection, and in their objection, they have filed 2 documents. One document of the voter list, and the other document is a declaration given by the testator Nakul Borua. And in that declaration, they have filed this document. In that document, the Nakul Borua has stated like this. Whether Shriman Prem Kumar Panjabi is the son of the opposing party number 6 and present petitioner.
No, that's all right. We'll not go into the factual aspect. Okay, Mr. Das, how prejudice is caused to you by this amendment?
Because, my lord, it will totally change the nature of the earlier pleadings, my lord. Plus, my lord,
What nature has been saying?
the explanation, which was not
No,
earlier
pair
there.
is same. Pair is for grant of
Prayer
probate.
is same, but
Then-
earlier that part, that way, why he had put his thumb impression instead of his signature, that part was totally missing in their earlier petition. So now, by way of this amendment, they want to incorporate that part after we filed the written statement to supplement, which was originally missing, and to fill up the lacuna. That's my case, madam. It's nothing but a case of filling up of lacuna, because that explanation was not there, and that's what is admitted by the other side also. That why a literate person will affix his thumb impression in such a vital document like a will instead of his signature.
No, my lord, in the paragraph number 3 of the amendment petition, the explanation was given by that your humble petitioner is an ordinary man, and as such, he has got no knowledge what statements are required to be printed. So everything depends upon the lawyer. My friend has submitted that the mistake done by the party cannot be the margin of the lawyer is not correct, Lord. That what statements are required to be pleaded in his pleading to prove a case, and as such, it depends upon his engagements and who proceeded with the case as far as that the new set of lawyers who having recently been engaged have found mistake as to the omission to state as to how the testator executed the will, whether by writing his signature or somebody as an instance of the testator, or executed by the will by putting thumb impression. That the testator, although was a highly qualified person, but some months prior to the execution of the will, he had been suffering from neurological disorder, for which he became completely unable to write his signature, and as such, he executed the will by putting his thumb impression, that is alia, and at this instance, the writer of the will took the thumb impression. These things were also not printed, my lord. Who took the thumb impression? These things were not printed. And at this instance, the writer of the will took his thumb impression in the will, and thereby the execution of the will was completed. So this process of execution by the testator was led to be pleaded in the prime due to the ignorance of the plaintiffs then advocate who prepared and filed the prime. So in order to prove the execution of the will by the testator by dealing with LTI instead of signature in letters, the writer of the will at the instance of the testator took the LTI of the testator, took the are to be added in the claim as a sub-paragraph of the paragraph number 3. That to be added sub-paragraph.
Okay, all right.
So, my lord, this portion is very important. The probate court will see about the genuineness of the will. If these things are not stated, if these things are not pleaded in the then how the evidence should be?
No, that's all right, but the question is the explanation.
This explanation was given because this lawyer, everything is depend upon this lawyer. He was given, and he has
Okay.
gone through the will.
Okay,
And
okay.
he has not made it.
Okay,
And
okay,
one particularly, he was also the writer.
okay.
When a
Why the writer himself?
when a pleading is filed, he is supposed to read and understand the contents, my lord. Now, after that, he cannot come and deny that he has not read the or he has not understood the contents.
No, Mr. Das, you say,
My lord,
whatever be the reason,
my lord,
they have supplemented it or by, or filled up the lacuna,
my lord.
yet you will get a chance to cross-examine them on that
Yes,
point.
but that will
You-
first they will have to overcome the, my lord, bar of proviso of order 617,
Mm,
the due diligence part,
mm.
that they have not been able to overcome, my lord.
No,
That's my only.
it is acceptable or not acceptable, that is a different matter, but there is some explanation.
There is that explanation that
Mm.
after the change of councils, then they have come to know. But my submission is that, well, that fact cannot be said to have been not known to the petitioner himself, Ranjit Borwa, that whether he had put affix his thumb impression or signature. Definitely he had instructed his earlier counsel.
Then he would have not engaged the lawyer. Why he has come to the lawyer?
The pleadings are not signed by the council. Pleadings are supposed to be signed by the person himself. He cannot take the plea that tomorrow I have not read or understood.
Okay.
To prove the case.
Okay.
To my lord, at this stage, the main opposite party have already submitted their written statement, and he has been taken time for submission of written statement. And 10,000 rupees has been already paid, and they have taken the 10,000 rupees.
Okay, okay.
And the case is pitched for the submission of amendment plan.
Heard Mr. Das, learned counsel for the petitioner, and Mr. B.K. Sharma, learned counsel for the respondent. Argument concluded, order reserved.
Highly obliged, man.
I am submitting with the lordship one certified copy. So, a certified copy. As to the position of the opposite party number 6, that is the petition. She's not at all in relation.
This goes to the merit of. These are
Will not go into that aspect.
Item for hearing number of the 41, item 88.
Kindly pass over the matter for the day. My senior is on legs.
Who is your senior?
Mr. G. Podoloy, he's for the petitioner.
Is your name, please?
L. Izum.
L. Ijung, learned counsel for the petition, learned counsel appearing on behalf of Mr. Z. Bordolo, and learned conducting counsel for the appellant. Price for passing over the matter for the day. Where allowed, the matter stands over for the day.
Item 28.
Lordship, I am appearing on behalf of the appellant here. The appellant possesses a plot of land measuring 18 lesas of land in Borpothar town in the Golaghat district. The respondent number 1 is his neighbor. He owns a plot of land adjacent to the appellant, and both of them has constructed an RCC building adjacent to each other. The respondent number 1 has constructed his building so close to the boundary wall that when it rains, the water channel of the building, the water flows into the building of the appellant. So the appellant, he complained about this fact to the Borpothar Town Committee for necessary action regarding the illegal construction. But what ended up happening is that they ended up demolishing my building instead on 23rd of March 2018.
Okay, you have suggested two substantial question of law.
Yes. No, I have suggested a substantial question of law. They have ignored material evidence and arrived at findings which are perverse.
Which part of material evidence is ignored by them?
Yes. Lordship, may I kindly come to the last page of this RSA, where in the paragraph in this regard, this is the report made by the executive magistrate after he made a field visit and he saw the reality on the ground. And this is him making the observation after seeing everything, that in this regard, it may be stated that as per Rule 66 for subclause 2 of the Assam Notified Urban Assam other than Gauhati Building Rules 2014 for medium density zones, the medium side setback shall be 1.5 meters, as in you have to leave 1.5 meters on both sides of the building. Towards the boundary, you have to leave 1.5 meters for medium density zones. This is the law set by the government. Now, Lordship may come to page number 95. That is my construction permission, which is granted by the Borpothar Town Committee. On page number 95, we can see the site plan. Here it shows clearly that the width of my plot of land is 35 feet plus.
No, that's not like whether this report was exhibited before the court below.
Yes, this is a part of the record.
Exhibited as exhibit?
It is mentioned in every judgment. It is mentioned in the trial court judgment as well as the appellate judgment. Lordship may come to page number 84. No, 85, Lordship. Likewise, Exhibit C, corresponding to Exhibit 7, enclosed report dated.
Page number 85.
Page number 85, Lordship.
This, that is the judgment of?
This is the judgment of the appellate court, Lordship.
In respect of issue number?
Issue number 3, the issue you'll find here on page number 75. Issue number 3, 4, and 5 are taken together. The issue goes like whether the plaintiff has constructed the building according to the site plan which was submitted by him during obtaining the construction permission. Whether the demolition of the plaintiff's building done by the defendant number 2, 3, and 5 is illegal, and whether the defendants are liable to pay damages compensation to the plaintiff for illegal demolition. So here is the issue, and on page number 85, the learned judge has finally come to the observation regarding this report that I have just mentioned in the last page. Likewise, Exhibit C, I'm reading from page number 85, Lordship. Likewise, Exhibit C corresponding to Exhibit 7 enclosed report dated 14th of May 2018 also highlight about the construction of right side of the building of the plaintiff attached to the boundary wall in violation of the existing rule. And by this rule, they are referring to the same rule that I have read before, rule number 66.4.2 of the Assam Notified Urban Assam other than Gauhati Building Rules 2014. Here, this rule is also mentioned about in the trial court judgment. Now, Lordship may kindly come to that.
And where it has been ignored, it has been discussed here.
Yeah, it has been discussed, but it has not been appreciated in the proper lights, Lordship. Lordship may come to page number 95, my site map. In this site map, we can see that the width of my plot of land is 35 feet plus. And on the very next page, on page number 96, here lies my home plan. In the home plan, they have approved of a home where the width of the total entire construction amounts to 30.2 feet. 10 feet plus 10 feet, 10.2 feet plus 10 feet, amounting to 30.2 feet. Now, if we go by the law, 1.5 meter has to be left on both the sides. So in feet, in terms of feet, 4.4 feet 11 inches on both sides has to be left out. Now, on per side, and if we add up or for both the sides, we which comes to 3 meters, it translates into 9 feet 10 inches approximately. So if the site plan they have approved is of a 30.2 feet home in a plot of land which is only 35 feet plus, so this amounts to this construction permission is itself illegal, is in violation of this rule. So when the government comes and demolish my home, claiming that I have not followed the rule, they have themselves committed the original sin, as in they have approved a home plan which is illegal. So now a man invests his entire life saving and he constructs a building, and now after constructing the building, they come and demolish the building, and later on they cannot claim, they say that they are not liable for any compensation. Now they cannot make the cake and have it too, Lordship. They cannot have everything their way. That violation of law is apparent here. Just the width of the plot of land is 35 feet plus, and they have approved a home plan of 30.2 feet. This is striking. This is a gross perversity that the trial appellate court as well as the trial court has arrived. So that amounts to a substantial question of law. They have ignored material evidence on record, both of this site plan, construction permission, home plan, the inquiry report, everything is on record.
Where is the trial court decision?
Trial court decision, my lordship, you will find on the relevant portion. I will point out, lordship, in that from the trial court decision.
No, where is the judgment?
The judgment starts at page number 17, annexure 2. The judgment is a bit voluminous, so the relative portion I can point out. May I read from page number 38, which is relevant?
Page number?
38.
Yes.
Yes, I will read from the in pertinent to be mentioned here that defendant side has not raised any objection against Exhibit C. As such, Exhibit C appears to be an admitted document. Perusal of Exhibit C shows that it is an inquiry report on the petition submitted by Sri Odhirnak, that is the appellant, a resident of Borpothar, Ward number 3. As per the report, the concerned executive magistrate Hansiri Horupothar did spot verification on 7/4/2018 against the petition of the Odhirnak. Then we will skip a few lines, then we will read. In the report, it is stated as per Rule 66(4)(2) of the Assam Notified Urban Assam other than Gauhati Building Rules 2024. For medium density zones, the minimum side setback shall be 1.5 meters. It is reported in Exhibit C that the same rule was not maintained by the petitioner as well as his neighbor Fonidas. So the trial court as well as the appellate court were very aware about the existence of this rule. They have gone through the report of the executive magistrate after he made a field inquiry. So all they had to do was go through the site plan and look at the dimensions of the site plan as well as the home plan. Then the perversity would have come on to the light. But instead of doing that, they have just dismissed the appeal as well as the trial, denying any compensation.
No, they have taken note of this exhibit C.
Exhibit C, Lordship. Which page you are referring to, Lordship? Yeah,
This annexure 8.
Annexure 8. Yes. This report is also taken into consideration. But
Then
they have not applied their mind, Lordship. They have 1.5 meter on both sides. If we take, then total 3 meters on both sides.
you see, substantial question of law, we cannot go into the facts.
No, this is not about facts, Lordship. Here, the Supreme Court judgment is very clear that if the appellate court ignores material evidence and arrives at a conclusion which is perverse, or
No,
it
where
arrives at a
the
conclusion which is opposite to the-
no, you tell me where the appellate court has ignored it. It has
Yes,
discussed
the
the
appellate court
exhibit
has
P.
ignored the site plan and the home plan. They did not compare the dimensions, Lordship. 35 feet and the home plan width is 30.2. They did not
Whether
compare.
the site plan was exhibited before the court
Yes,
below.
it is a part of every record. The first thing they should have done is take a look at the breadth of the plot of land and the breadth of the approved home.
We'll list it again for further consideration.
Lordship.
Third, Mr. Your name, please?
P. Borborua.
P. Barbara, learned counsel for the appellant. List this matter on cover. Second, right?
11th March.
11 March for
11
further consideration.
Deeply obliged.